I actually don't know that answer. I am going to see if the girls and technical connection for maybe she would know. Okay? Thank you. And this is your number, so I will share her contact with you, and I will trouble you. Okay? You're welcome. Everything got confirmed up since Rose was there, so if she calls, she knows why she's calling. You're going to call for somebody, okay? I just wanted to give you a heads up on the text that I sent you. If you get any other random calls, that's why. I think I gave you the belt, but I don't know if I have it. I gave you whatever I have in my phone. Okay, thanks. Bye.
Did I not say that? It's the lawyer. That's the lawyer.
Yeah, it's Harper.
What's his name? Napoleon? No, Napoleon.
How many people did you say are in here? About 75?
Pardon?
How many people do you think are in here? About 75 people?
No, yeah. Yeah. All right, we're gonna.
Right.
Which one? Yeah, the blue. Let me.
Huh? They're not going to be in the box.
All right, so.
You don't see Alex, the IT guy.
I thought I recognized his face somehow. Yeah, just.
You don't have a dog. These are our cases.
Okay, what's your insult? That's like the table. So this guy is your social or that he approves, that way the guys don't see his name.
side. If so, please come forward. Thank you.
Oh, good. So I should have used that. I didn't see any underneath. I have one.
may be seated.
Morning.
Morning, Ron.
Your Honor, we have, I think, 3 matters on the docket, state grand jury matters for Your Honor's consideration today. I believe in speaking with the state grand jury clerk that the first case up for status is the State versus Russell Lucius Laffitte. Again, to remind Your Honor, he's been indicted in 2022 GS 4701, venue in Hampton County. This is a state grand jury indictment containing 4 white-collar counts. 2022 GS 4702, that's venue in Hampton County, 3 white-collar counts. And then finally, 2022 GS 4703, venue in Allendale County, which contains 14 white-collar counts, a total of 21 charges with an alleged loss of about $1.8 million. Mr. Laffitte is here, present with his counsel, Mark Moore and Todd Rutherford. And again, I think we're here to status the case and to discuss a trial date. I'll let
Not to discuss the trial date, to set a trial date.
and the state is prepared to go forward at whatever date works for all parties. I think the defense has a different position, and so I will let them at this point raise whatever issues they wish to raise unless Your Honor has any specific questions.
All right. Mr. Moore?
Morning, Your Honor. How are you?
Fine.
So, things have not changed much on the federal side since the last time we spoke. Mr. Laffitte's bond motion
For the internet?
is still pending with the 4th Circuit. The 4th Circuit has not yet decided it. I thought we would have a decision by today.
It's what kind of motion?
It's a motion for an appeal bond. He is scheduled to report on September 21st, unless the 4th Circuit grants him an appeal bond. I had a briefing scheduled in this case, in the federal case. They briefed it at the end of September. The government crossed appeal, and after the government crossed appeal, the 4th Circuit consolidated those cases. I don't have a new briefing schedule, but I'm going to get a briefing schedule in the federal case.
All right, so you're here to talk about the federal case. I'm here to talk about this case, the state case.
Well, Your Honor, I'm just telling you, because they have some relationship to each other.
What is the relationship?
The relationship, Your Honor, is that much of the evidence is the same. Okay? Much of the evidence is the same. And as Your Honor knows, and I know that these cases are scheduled separately, but my client is charged in 3 separate cases with Mr. Murdaugh. Okay? They are co-defendants. No motion to sever has been filed. Okay? And so, as I understand it, the state wants to try a case involving Mr. Murdaugh that does not involve my client first. My client has been convicted in federal court, and
We're going to set this case aside and proceed with Mr. Murdaugh's case, and then we'll come back to this case.
so you want to set aside the money?
That's what I just said, yes.
Thank you, Judge.
Your Honor, can we have Mr. Murdaugh?
Yes, sir. Morning.
Your Honor, this is State versus Richard Alexander Murdaugh. Your Honor is aware he's been indicted in a slew of state grand jury charges, and I'm happy to read those numbers into the record. They are extensive. We have 2021 GS 4727 in Orangeburg County, containing a number of white-collar counts. 2021 GS 4728 in Bamberg County. These were indicted in the state grand jury in November of 2021. We have 2021 GS 4729 in Allendale County, also indicted in November 21. 2021 GS 4730 in Beaufort County, also indicted in November 2021. 2021 GS 4731 in Carleton County, also indicted in November of 2021. 2021 GS 4732 in Hampton County, indicted in December 2021. 2021 GS 4733 in Hampton County, also indicted in December 21. 2021 GS 4734 in Hampton County, also indicted in December 21. 2021 GS 4735 in Beaufort County, indicted in December 21. 2021 GS 4736 in Hampton County, also indicted in December 21. 2021 GS 4737 in Hampton County, indicted by the state grand jury in December 21. 2021 GS 4738 in Carleton County, that's indicted in December 2021. 2021 GS 4729 was a superseding in Allendale County in January 2022. 2022 GS 4701 in Hampton County in January 2022. 2022 GS 4702 in Hampton County, that's January 22 was when it was indicted. 2022 GS 4703 in Allendale County in January 22. 2021 GS 4727 superseding in March of 22 in Orangeburg County. 2021 GS 4730 superseding in Beaufort County in March of 2022. 2022 GS 4701 in Hampton County in April. 2022 GS 4702 in Hampton County in April. 2022 GS 4703 is superseding in Allendale County in April of 2022. 2022 GS 4710 in Carleton County in June of 2022. 2022 GS 4723 in Hampton County in August of 2022. 22 GS 4724 in Carleton County in August of 2022. Finally, our last two, 2022 GS 4734 in Hampton in December of 2022, and 2023 GS 4703 in Carleton County, indicted in April of 23. Your Honor, the state grand jury indictments that I've just listed against Alex Murdaugh represent 101 total charges for an alleged loss of almost $8.8 million. Your Honor, the state is here, as we have discussed, I believe, back in April, requesting a trial date for Mr. Murdaugh. I believe that we look at some of the other co-conspirators that Cory Fleming has pled was supposed to go to trial this week. But Mr. Murdaugh remains the state's priority, and I believe the case that is the priority would be the case involving the Satterfield, Your Honor. That by far represents the greatest single loss among all the victims. That would be 2021 GS 4730, venue here in Beaufort County. And the state is intent and requesting the court to schedule a trial date as soon as reasonably possible, sometime before the end of this year, to try Alex Murdaugh on those particular charges.
All right, Mr. Harper, yeah. Yes, sir.
Your Honor, there are a number of different objections we have to trying any of these cases this year. We previously got the impression from Your Honor when we met at the last status conference that you would not be trying any of these cases, and you'd be leaving the bench on January 1.
Tell me about that impression again.
That was my impression based on your discussion. Now, maybe I misread you. I've done that from time to time during the process. If I did, I apologize. But in the meantime, Mr. Griffin and I have scheduled other matters for this fall. Both he and I have a federal trial in December. Before that, Your Honor, and I think I mentioned this the last time we talked, I have the oldest case in Lexington County, civil case, involves the death of 5 children killed by their father who was sentenced to death for it. We sued the Department of Social Services 8 years ago, and finally on a trial docket. I've mentioned this something I missed.
It's on a trial docket for when?
Motions on the 14th of October, trial on October, and I have a email here from Judge McCadlin who's trying a trial on, motions heard on October 13th, trial roster for October 30th. And it's at least a 2-week or 3-week trial. Mr. Griffin has an additional conflict in Texas in a federal trial. What day? October 30th. October 30th that week. So I guess this is September. It looks like most of October is going to be involved either getting ready for or trying that case. Wouldn't be done until early in November. And Your Honor, you know, it's going to take some time to get ready for these cases. But more importantly, and maybe this is the toughest thing I have to say, and that is this. This case was finished 6 months ago. It clearly, I don't think anyone would dispute, has had more publicity than any case in the history of this state, and maybe the country. On national television every day for 6 weeks. The motions motions hearings were covered, and they're here again today. It has been podcasted, blogged. We've got podcasters out there who are gripping their 15 minutes, hanging by their fingernails, wanting more of their 15 minutes of fame, and continue to talk about this. I understand one of the solutions to massive pretrial publicity is a change of venue. There are 2 cases I want to cite to the court, both of the United States Supreme Court cases. Murphy versus Florida, and the cited, in Shepard versus Maxwell. There are 2 kinds of pretrial publicity that would indicate a continuance and/or a change of venue is required. Prejudice is presumed for pretrial publicity when pretrial publicity is sufficiently prejudicial and inflammatory, and the prejudicial pretrial publicity saturated the community where the trials were held. They found presumed pretrial publicity in a case much less renowned, much less publicized than this one. And Your Honor, to try this case in less than a year after the verdict came in the other case, don't we need to let it calm down a little bit? Where are you going to get a jury? Mars? I mean, there's nowhere in this state.
Allendale, Orangeburg, Beaufort, Colleton,
Your Honor, and I
Hampton.
appreciate your sense of humor.
It's not a sense of humor. We have many counties where these indictments were issued. I am not presuming that a jury cannot be impaneled. Just as the trial that took place on Colleton County, there was no motion to change venue. And I'm not presuming any prejudice, and the test is not based on speculation. The test is whether or not a jury can be impaneled. You first have to attempt to get a jury according to the law.
What I'm saying is, I think it'd be an exercise of futility. I know this. We've been interviewing jurors, as you know, in the murder trial. There was a juror who on that jury, who could have been excused, been on the jury panel within the previous year, and told other jurors, I want on this trial, I want on this trial. And that, I'm afraid, is what happened on that jury. We got a motion for a new trial for after discovered evidence. The Attorney General is going to file their response tomorrow. We believe the Court of Appeals will order a hearing before a circuit court judge to determine whether or not the clerk of court tampered with that jury. And that is and so we would go forward with another trial while that matter is pending, while that matter is being litigated.
Probably not in Colleton County.
Well, Your Honor, the idea that somehow something happens in Colleton County doesn't affect what happens in Beaufort County. I mean, this is a national case. I mean, do they not have television in Allendale County?
I don't
Do they
know.
not have the internet?
I don't know.
What's the hurry? That's the other point. What is the hurry? He's pleading in federal court next Thursday. Every allegation the state has made, the victims will have their day in court. We plead, Mr. Murdaugh indicated he pleaded guilty to the state charges, but the state insists on doing them in serial so they get 3 convictions so they get life without parole on a guy who's already serving 2 life sentences without parole. This is just another attempt to get more publicity, to make this another national case. And, Your Honor, I'm offended that the Attorney General he's got many other cases that are much older than this, but granted, court TV won't be there for them. This is another effort at creating a national spectacle. Now, Your Honor has some things to say about Mr. Murdaugh at his sentencing. You obviously believe he's guilty of that. You obviously, and the jury found him guilty of that. But I would ask you to put those feelings aside and give us a chance to litigate this jury tampering issue, to allow Mr. Griffin and I to have time, if there is going to be a trial on these, to prepare for those trials, which we won't with our calendar for the fall. And third thing is, why doesn't the Attorney General put some distance between the conviction in the murder case and the trial, if there has to be a trial, on the financial cases? I'm, as you know, as a prosecutor, I'm bewildered by this. Certainly they can do it, but why? Why? What is the hurry? Thank you for some notes. Thank you, Your Honor.
Your Honor, this isn't about a spectacle. These white-collar indictments have been investigated by the state grand jury, which is a partnership with the AG and SLED. And these particular, the Satterfield indictments were indicted in November of 2021, just about 2 months after the side of the road happened. This is about allegations that represent an assault on the state judiciary. And because of that, they need to be answered. Your Honor is exactly correct that the law does not presume prejudice. If he wants to file a motion where he cites law, then we can respond, but the law is very clear. Is that you don't presume prejudice, you try to seat a jury. And only through that process can the court then assess whether or not a jury can be seated. We are in 2023. The reality of the media environment is what it is. And unless we're going to say the judicial system just can't function because of publicity, that just leaves nothing left to happen. This is just the reality that we live in. And so we depend on the ability of the system, we depend on the ability of the jury selection process to seat jurors. And that is what should happen. And only if there is an inability to do so can this court then consider whether or not there needs to be some change of venue or some relief or something like that. That is exactly what the process should be. And this is a big county, this is Beaufort County, and fundamentally, just as we rely on lawyers, just as we rely on judges to be objective about what they do, and that includes the defense motion here, okay? We have an objective duty. We also the system depends on jurors to be objective as well. And to just say, because there's publicity, nothing can be done, just throws the system out and leaves no recourse whatsoever. And what the defense can't do is try to essentially run down the street to the federal authorities and bypass the accountability that needs to happen in state court for a direct assault through use of a state law license on this courtroom, Your Honor, on the other courtrooms or the other counties that I named. The state judiciary needs, the state judicial system needs to answer for the allegations of this assault. And that's why this is important. That's why this case has priority, and that's why the state seeks to move it forward.
Briefly, Your Honor.
Yes, sir.
Well, this wasn't his argument a year ago when he called the murder case first. The murder case was indicted after the financial crimes, and it wasn't that important then. Now, all of a sudden, it's, the most important thing in the world. I would suggest, Your Honor, that he made a decision to try the murder case first, not the financial crimes. And as a result, we've been put in the position you know, of where we're at today. In addition to that, I would state for the record, I want this clear, based on our, that is, Mr. Griffin and my trial schedules in other cases between now and the end of the year, we would be ineffective in preparing for this trial, any trial.
Your Honor, that is absolutely not what happened. I even said I was happy to try the white-collar cases first. It was the defense's motion for a speedy trial and Mr. Harpootlian's waiver of his legislative immunity, which is what led to the murder cases being done before. It was the defense that wanted to trial the murder case. They filed a motion for speedy trial, and the state said, okay, let's do it.
His decision to agree with that, Your Honor. It was up to him. He's calling the case today. The solicitor calls the case, the prosecutor. We don't call the case. It was his decision. He decided to go with the murder case first.
Your Honor, the state is happy to show up in court and seek justice for these very important matters whenever a date can be scheduled. And the only reason the murder went first was because of Mr. Harpootlian.
Well, the court's not going to defer to Texas in setting a trial date. And a trial date will be set prior to the end of this year. You all have a choice of either the week of November 13th, November 27th, and there's an Allendale term scheduled. Or December 11th. You will have a choice of either of those 3 weeks to try whatever case is pending in those individual venues.
Your Honor, could we confer and email you today on what our preferences are?
No, we can confer and resolve it this morning while we maybe move on to the next matters. We have other matters.
State will take anyone.
Your Honor, without waiving my previously made objections, November 27th would allow us to deal with these other trials, although not really give us time to prepare for this, because you've already heard my position on that.
Well, November 27th, let's see.
The Monday after Thanksgiving.
All right, let's see. And we're attempting to coordinate with other existing terms of courts in the various places. All right.
Your Honor, where's the venue on November 27th?
I'm open to whatever venue. The predominant number of cases are pending in Hampton County.
The state's preference would be to do the Satterfields in Beaufort because that is the greatest single loss. But if there are scheduling issues, we will do Hampton. I do believe that it makes the most sense to do that one first just because of the way this case is developed. And so the state would seek to call that one first in Beaufort County.
Let's see. 27th, there is a general sessions terms scheduled here in Beaufort County.
For the 27th.
Yes.
That works for the state, yes, sir. Obviously, I need to coordinate with the solicitor's office as well. Absolutely.
No, we'll take care of whatever coordination is necessary, unless there's a death penalty case scheduled that week.
Thank you, Your Honor.
All right, so the case is set for trial on November 27th.
That's the Satterfield case, right?
Is that the matter you're seeking, the Satterfield trial?
Yes, sir. That would be, of course, relevance. 2021 GS 4730.
Thank you for indulgence, Your Honor. Your Honor, nothing else, I'm sorry. We're trying to...
All right. Do y'all want to set a deadline for any motions that might be filed?
Yes, sir. I think that's advisable. If I can look at my phone real quick, Your Honor. I would say because of the week prior, obviously, is Thanksgiving, that perhaps the Friday the 10th might be the best day for motions, and then responses to the following week. Maybe by Friday the 17th. I think if we have significant pretrial issues, it might even make sense to have a hearing prior to the trial date so that those, if there's resolution of those, we can hit the ground running with that trial week.
Your Honor, none of this is a big concern. I don't know why we just can't deal with it that morning. I mean, our schedules really are complicated. Can't we have the hearing that morning?
The morning of the trial?
Yes, ma'am. Yes, sir.
Well, a deadline for filing the motions.
I don't have a problem with that. 10 days prior to trial, and responses 5 days before trial.
Okay. I think, in effect, that's what you proposed.
Yeah, Your Honor, and I apologize, the 10th is Veterans Day. We could have the motions filed on the 17th.
My God knows I don't want to have to work on Veterans Day. Oh, my God.
I just pointed that out, Your Honor.
I know the state government people enjoy these holidays, but we're going to have to rearrange a major personal items to deal with this. I plan to take Thanksgiving and visit my wife overseas. That ain't happening now. I've got to call her when I leave here to tell her. So perhaps we'll have to work Veterans Day. I'm sorry. I suggest that.
I would say these people next to me work just as hard as they do, and Your Honor saw that.
We'll be working Veterans Day, so why don't you match us?
That's a deadline. Maybe you'll have it prepared the day before. Veterans Day is on the Friday the 10th, is that it? Well, the deadline will be Thursday the 9th. How about that?
And then responses in 5 days.
And responses in 5 days will determine when and if a hearing is needed prior to the 27th. If you'll put all of that in order and circulate it to council for any comment, and I'll sign a written order addressing all of what we've just discussed.
Well prepared, Your Honor.
Now, anything else we need to talk about in this case?
Your Honor, I hate to rise.
I said in this case. No, you're not in this case, are you?
Yes, Your Honor, but
Well, we're coming to you next.
I know I'm just charged with him in the other cases.
You're charged with what?
My client is charged jointly with Mr. Murdaugh and 3 other cases that have not been scheduled.
Well, he's indicated he's calling the State v. Murdaugh, State v. not Murdaugh, yeah, State v. Murdaugh in the Satterfield case. Unless you want to voluntarily join in.
Your Honor, I do not voluntarily join in anything.
All right, well,
Your Honor, I apologize, Mr. Moore, he just has to say it.
all right, well, thank you all very much.
Thank you, Your Honor.
We'll take 2 or 3 minutes and then move back to the Laffitte matter.
judge's microphone is very close to him, so still way hot. Okay. Okay, so right now, we're still, okay, I'm going to turn down. So you should be able to hear me. Right, but there's a game that should be coming in still. How's that coming in now?
Thank you. You may be seated.
Your Honor, we're back on the record, State versus Russell Lucius Laffitte. Again, he's here represented by counsel Martin Warren, who was here. Again, back here to discuss status in a trial date. And as always, Your Honor, the state is prepared and will be prepared to go forward in any date that the court sets. I know the defense has some issues with that, so I will let the rest of Your Honor.
Can you remind me about Mr. Laffitte's various indictments and venues and all that?
Yes, sir. For Mr. Laffitte, we have 2022 GS 4701 and 2022 GS 4702. Those are both venues in Hampton County, and those deal with the victims there are Ms. Thomas and Christine Pinckney. Then in Allendale County, we have 22 GS 4703, again venued in Allendale County, and that the underlying victim there is Mr. Badger. 2 in Hampton, 1 in Allendale, Your Honor.
All right, Mr. Moore?
Yes, sir, Your Honor. He's charged with Mr. Murdaugh on all 3 of those cases. They're co-defendants in all 3 of those cases. I would ask, Your Honor, because as I understand it, the state wanted to go first with the Satterfield matter. That case has been set. I would ask, Your Honor, to set a trial date for one of these cases in the fall of next year. As I mentioned, and I know Your Honor doesn't want to hear about the federal case, but it's inextricably intertwined here, and one of the things that I have to do to represent this thing is that I've got a briefing schedule, and we've got to deliver a briefing before Circuit Court of Appeals this fall. We have to do that. I don't have any choice in that matter.
To deliver briefs where?
to the Fourth Circuit Court of Appeals.
Fourth Circuit Court of Appeals,
Yes, sir.
concerning what?
Well, so he is appealing his federal conviction. And so the Fourth Circuit set a briefing schedule, and they originally set a schedule for September the 28th. As I mentioned earlier, the United States Attorney's Office then filed a cross appeal. The Fourth Circuit consolidated those matters. They abrogated the briefing schedule, but now they will set a new briefing schedule. I expect to get a briefing schedule in the next week or two, and I expect, because of how quickly the other briefing schedule was set, that we'll go to a briefing schedule where that briefing will be due at the end of October, or maybe, if I'm lucky, mid-November. I've spent way more time focusing on the state may have a page now. We have not been through that discovery, and I'm going to need the opportunity to do that with Mr. Laffitte. That may be very complicated because, again, I don't know today, perhaps we'll know by next week, whether he's going to get an appeal bond or not. If he does not get an appeal bond, he's going to be in Coleman, Florida. That's where he's been designated to serve his sentence. And I need some time and some access to him to be able to prepare for his defense in this trial. And so I would again, Mr. Rutherford, as legislative immunity, as Your Honor knows, I understand that the state may want to talk about trying the case in spring, but I would ask Your Honor to set, and perhaps, I don't know if the state intends to try all three of these cases or not. I don't know what the current is. I think Mr. Waters can speak to that. I'm not prepared to speak for it. But I would ask Your Honor to set those cases for the fall. That's what I would ask. Thank you. I can tell you, Your Honor, that I will have motions filed in those cases. And I can get another. But I'm just saying, I don't see physically how I can try this case with this client this fall, given not only that appeal, but this discovery. I would be ineffective, I believe. And I don't want to be ineffective for this man.
All right. Mr. Waters.
Your Honor, as to the discovery, first I'll point out, and I'm not unsympathetic to the fact that Mr. Moore and then much later Mr. Rutherford have now joined the defense team, but that's not the state's fault that Mr. Laffitte changed lawyers. The discovery of this matter had been out for a long time, and again, it is extensive, but as he said, much of the discovery is very similar and were generated by the state grand jury as to things that they've been reviewing in the other matter. The discovery we provided is base labeled, a very detailed Excel sheet that goes through all of that. But ultimately, Your Honor, there is a distinction between what has been previously tried in the federal court, which again, it's not what's going on here. In that particular case, what was litigated, what was indicted by the federal government after the state grand jury had indicted the case was Mr. Laffitte's providing with the $750,000 undocumented loan to Alex Murdaugh, as well as providing the $680,000 to the law firm when all of this started to come to light. And they did present some of the evidence of the underlying victims as the sort of the background to leading up to what they charged here. But what's charged in the state grand jury is the underlying offenses of these victims. The victims being Ms. Thomas, Mr. Hakeem Pinckney, Mr. Badger, and that's a distinct matter, and that actually goes back for almost a decade or more. So we believe, Your Honor, that again the state is prepared and happy to come try this case whenever Your Honor finds a date, and we're happy to do it in the fall as well. If that's not going to work and Mr. Rutherford wants to look at something in the spring, I guess we could talk about that, but I think, the fall is really our sweet spot for trying to get some of these things moving. What I don't want to have happen is just to defer anything until all the way to the fall of '24. Again, these cases go to the heart of the South Carolina state judicial system. It's important that these allegations be litigated in court. And just deferring everything into the fall of '24 and going through the same process again in the hopes that something can get scheduled prior to the safe zone being reached again, I just don't think is appropriate for justice in this particular case. So again, the state is here. The state, if the date gets set, the state will be prepared and ready to go try the case.
Yes, sir.
One brief point. So I don't necessarily, I didn't try the federal case. Okay, I came in after the fact. But I have reviewed that transcript, and I reviewed the indictment, and I don't necessarily agree with Mr. Waters. The federal government didn't just charge those 2 bank fraud counts. They charged an underlying mail-and-wire fraud and bank fraud conspiracy that included the conduct reflective of Mr. Laffitte and Mr. Murdaugh's dealings with the alleged victims who were in this case. So there were counts that dealt with those victims. I tell Your Honor that to tell you that because I think Your Honor should know that. And those folks testified. The one thing that is, and I'll tell you what I have not done yet, I have not tried to relate the discovery that we've gotten in this case with the discovery in the federal case. They're different. But in this case, there's the testimony of 30 separate grand jury witnesses before the state grand jury. I haven't read those transcripts, Your Honor.
You have not read those
I
transcripts?
have not read those transcripts as of yet.
When is the first time you appeared at a status conference in this case and requested more time?
I appeared at the status conference, I believe, back in April, Your Honor, and we've been dealing with the federal case ever since. And I understand that the federal case is different than the state case, but I was not aware until today that we might be talking about trying a case in the fall. And that's on me, okay? And if I have to get ready, I have to get ready. But I have not read all 30 of those transcripts. I have not. I have looked at a couple, but I have not read all 30 of them. I have not.
Yes, sir.
Even back in April, we were saying that we were ready to try the case whenever a date could be set, and expressed then that we were looking at the fall. And I think that Mr. Rutherford had just joined the defense team the day before, and I remember the exchange very clearly. He said, well, I haven't even gotten the discovery yet. I was like, well, we just joined the case yesterday. So, I mean, again, the defense has had this discovery for a long time. This is September now. This is 5 months later. And again, I understand the difficulties the defense is facing, but this case has been indicted. The discovery has been to the defense team for an extended period. And if we don't get this done before the end of the year, then we're looking at the fall of '24. And I just believe that's too long to wait for the importance of the allegations here.
When is the other co-defendant's trial scheduled? Is that Roberts or?
That is December 18th.
Is it Roberts?
Yes, sir.
December 18th?
Yes, sir.
What was the length of the federal trial?
I believe it was 2.5 when you count actual days, Judge.
2.5 weeks.
2.5 weeks, Your Honor. When you count opening statements and jury deliberations, I believe it was 2.5 weeks.
All right. Mr. Rutherford?
Yes.
Yes, sir. Anything you want to add to the discussion?
Your Honor, this is, as has already been stated, a case that took 2.5 weeks to try in federal court. These are allegations that our client has already been convicted of. Judicial economy asserts that he has already been convicted. He is appealing that case. We're working on that appeal, trying to get that into the Fourth Circuit. The state has the ability to call any case they want to and keep their foot on the gas, and this is all that they get to focus on. Judges can't make them call other cases the way the judges have made me work on other cases. We tried a murder case 2 weeks ago in Spartanburg that was a 2017 case, I believe. Almost every case that I have scheduled between now and the end of the year is older than this one. And several of them that I have are also with the Attorney General's office. Whether they call them, schedule them, or not is up to them, not up to me. What I foresee them doing is trying to assert that they're ready, willing, and able to go. They'd love to do it in the spring. They just want me to waive my legislative immunity. Which, Your Honor, for the record, I'd happily do if they waive their ability to call cases whenever they get ready. If they waive their ability to only work on one case solely. We don't have that ability. The case that Mr. Arpulian and Mr. Griffith spoke of earlier in federal court in December had a similarly situated co-defendant. Their client is actually for trial. Mine is not, but possibly scheduled for that same week because it's the same facts.
Not the week of November 27th.
Not the week of November 27th.
Okay.
And as they have already stated, that week is reserved for the case that they decide to call, which involves the Satterfields, not the case that is connected to our client. And so that's what they chose to do. They have not told us exactly which case they choose to proceed on. And during the break, he said, that's up to him as to which case he's going to proceed on and when. And it is, unless he's willing to waive that. Until that point, Your Honor, 41,000 documents. There's a transcript that goes for 2.5 weeks in federal court, all of which there is no way that any lawyer could be prepared on between now and the end of the year if they're going to do their client a service so that the state can have justice. Justice at what cost, I'm not really sure. I know that there are victims in other cases that are awaiting their date. I was in court yesterday on a 2016 case and had to answer to Judge Colville as to why the case was so old. Well, this is the reason why cases get old. Prosecutors get to decide when they call it. They get to decide when they get their foot on the gas and stay there and demand that a case that was indicted in April of 22 now must go to trial before the end of the year, pushing aside every other case that is much older for an individual that has already been convicted and sentenced and got his designation in federal court. There is absolutely no reason, Your Honor, we would assert, for this case to move forward, and if so, it would require for a December date that I not be present during JMSC for the entire month, where we're screening, I believe, almost 100 candidates for judicial seats. There's no way to do that and prepare for this. My schedule, Mr. Moore's schedule, the attorneys that have worked for us, getting together with Mr. Laffitte, it would require what the state already has the ability to do, which is put everything to the side and work on what they want to. We don't have that ability. When they waive that and give that up, I will give up my immunity. They will not, I will not. And that is why I believe that a trial date placing us in the fall is reasonable. The fall of 24 is reasonable, given the factual circumstances in this case.
And Your Honor, if I could just add one other comment, that's, if Mr. Laffitte's federal appeal is unsuccessful and his conviction and sentence is upheld, then he may have decisions to make about these cases that might not require a trial. And so I tell Your Honor that because I don't think anyone wants to go through a trial and put the taxpayers to that expense if necessary. And I tell Your Honor that because I think I'll. Okay.
All right, Mr. Waters?
Your Honor, as to Mr. Rutherford's comments, he knows full well, of course, that when he's talking about cases in a particular circuit of the solicitor's office, that I have no control over that. What I do have involvement in and control over is the state grand jury charges. And obviously, Your Honor has been assigned by the Chief Justice of the South Carolina Supreme Court to preside over these matters. And so that's what we're here to deal with today, not what's going on in a different circuit in some other case. Mr. Rutherford elected to get involved in this matter. I'm not unsensitive to scheduling issues, but the state is here to say that if Your Honor sets a trial date, we will be ready and willing to try that case. And again, state grand jury, it's its own docket, it's its own method of going forward. What the state grand jury focuses on are cases like this that are can be complex white-collar cases and cases that have a lot of underlying importance to the system itself. And again, my charge and the charge that was given to me by the Attorney General is to prosecute state grand jury cases, and that's what we're here to do. That's completely separate from the dockets that Mr. Rutherford may be dealing with in a different circuit elsewhere in the county and state system. So we believe that we're here, and again, he's saying that I'm calling the cases. We're here to say, Your Honor, give us a date, and we will try one of these cases. We can do the two Hampton cases together. They are similarly, they were both part of the same action. The Allendale case is a different case. That would need to be somewhere else. So if there was a case to do, it would probably be Hampton. We could do the two indictments there. But we are willing to try a case if Your Honor finds a date that works.
And Your Honor, what I would say back to that briefly is, if he wants to consolidate the Hampton cases, he didn't indict them together, I guess he'd have to make a motion to consolidate them, and then we'd have to respond. And I'm not in a position to tell Your Honor exactly what my position would be today. But I'll do whatever Your Honor tells me to do.
Okay. Anything further?
Go from the state, Your Honor. At this point, I think we're done, Your Honor, but happy to answer any questions.
When do you expect to know whether Mr. Laffitte will have to report to the federal institution?
Well, as I think I told Your Honor the last time we were together, which was a couple of weeks ago in King Street, I expected to know today, and that's one of the reasons why we all talked about setting the status conference today. I expected to know today. Our briefing has been concluded in the Fourth Circuit for several weeks now. And the Fourth Circuit is aware of the fact that Mr. Laffitte has a report date of next Thursday, a week from today. I've talked to the United States Attorney's Office about asking Judge Gergel. Judge Gergel has deferred his report date once because of the pendency of the Fourth Circuit's decision. If we don't have a decision today, and I'm expecting that we're not, Judge, I just checked my email to see if I'd seen anything, and we don't have a decision. If we don't have a decision today, I'm going to ask Judge Gergel today or tomorrow to extend his report date one more time, and the government told me they'd tell me what their position was at the end of the day today. I had that discussion with them yesterday, not this morning, but yesterday. But as Your Honor understands, if he does get a report date, and his appeal bond is denied, and he is transferred to Coleman, that's going to make it way more difficult for us to get ready to try a case this fall. Way more difficult.
Way more difficult to try the case this fall.
Yes, sir.
No.
Yes, sir, because I won't have access to it. asked for a Judge Gergel asked the Bureau of Prisons to designate him to Jessup. They designated him to Coleman in Florida, which is about 5 hours away.
Now, you have the ability to request where someone serves their time?
Judge Gergel has the authority to recommend to the Bureau of Prisons, not order, but recommend to the Bureau of Prisons that a person be incarcerated in a particular location. The Bureau of Prisons does not always and regularly does not accept those recommendations. That is, I don't have that authority, the judge has that.
Did he accept your recommendation?
Judge Gergel recommended that the Bureau of Prisons incarcerate him at FCI Jessup, and the Bureau of Prisons.
And what state is that in?
Jessup is in Georgia. It's less than an hour from his home. It's sort of right over the Georgia border. And the Bureau of Prisons' general rule is that they're going to try to place you no less than 500 miles from where you reside, and he is in Coleman.
All right, any other words of wisdom?
I wouldn't say, Your Honor.
No, Your Honor.
I got plenty, but I'll say.
Well, I think we'll defer any decision about a trial date today until we can review things maybe in another month or 6 weeks or so and see where it all stands.
Thank you, Your Honor. We very much appreciate that.
All right. All right.
And Your Honor, I assume that if he gets a report date and we know he's going to be transferred immediately, Your Honor would expect me to notify the court?
Yes, sir.
And-
Very well.
Thank you, Your Honor.
All right. Thank you, Ron. We'll take 5 minutes and then proceed with Flemming. Yes, sir.
May it please Court, Your Honor, we're here on the State versus Cory Fleming. Mr. Fleming is present with this counsel, Debbie Barbier and Nathan Williams. As Your Honor is aware, back on August 23rd, 2023, Mr. Fleming pled guilty to all the state grand jury charges against him. Those are 23 separate charges. Just very quickly to detail those. The first one is 2021 GS 4730, which was indicted by the South Carolina State Grand Jury in March of 2022, and that alleges 18 counts against Mr. Flemming for victimization of Gloria Satterfield's estate and ultimately her sons as beneficiaries of that estate. And I would point out that we do have representatives of the Satterfield family here today, as well as their counsel, Eric Bland. I believe some of the victims want to address the court at the appropriate time. Your Honor, we also have State Grand Jury Indictment 2022 GS 47-2. That was indicted by the South Carolina State Grand Jury in April of 2022. And that alleges 5 counts against Mr. Flemming, and that is where the victim is Ms. Pamela Pinckney. And we have here Representative Ms. Pinckney, Justin Bamberg, who was here. Ms. Pinckney wanted to attend, was unable to make it, but Mr. Bamberg will be speaking on her behalf here today. Your Honor, I'd like to, I know we went through a very extensive factual basis and put in a number, over 20 exhibits at the plea. And as I described it at the plea, I think that the issue here is if we were in traffic court and the speed limit was 55, and Mr. Flemming wants to say, well, I admit I did 58, and the state, if I'm the trooper, I'm like, no, Your Honor, we clocked him doing 90, weaving in and out of traffic like a video game. And so what I'd like to do, Your Honor, with the court's indulgence, is just kind of detail some of the facts that show the true and real extent of the conduct here, because again, it does go to the heart of the state judicial system. Your Honor, these allegations here involve the use of state law licenses in state court actions before state judges with state court approved settlements. So ultimately, Mr. Flemming has admitted to a violation and abuse of the state judicial system. And because of that, Your Honor, I would submit to the court that the state judicial system must defend itself. It must provide its own accountability for those who would abuse it. And that is what the state, and I believe the victims, will be asking Your Honor to do here today. Mr. Flemming admits that he conspired with Alex Murdaugh to steal money in both the Pinckney matter and the Satterfield matter. He admits that, Your Honor. He admits to colluding with Mr. Murdaugh in the Pinckney matter when he was recruited by Mr. Murdaugh to represent Ms. Pinckney because she was a driver in the crash, but also a plaintiff, and so they needed another lawyer involved in the case. Mr. Murdaugh represented the other clients, including Hakeem Pinckney. And in the Satterfield matter, as Your Honor has heard, Mr. Murdaugh recruited, put these cases in Mr. Flemming's lap. In the Satterfield matter, where Mr. Flemming was going to represent the estate and represent the sons of Miss Gloria Satterfield, but Mr. Flemming was going to openly, behind the scenes, collude with the defendant in that action. Not the attorney, but the defendant himself. And what Mr. Flemming, I think, wants the court to believe is even though the state grand jury, he initially reported to everyone that he was a victim of Mr. Murdaugh just like everybody else. Just like Mr. Murdaugh's law partners and just like his clients, he was tricked and fooled by Mr. Murdaugh just like anyone else. But what happened was the state grand jury, which again is a partnership of the Attorney General and SLED, and the people sitting around me and the SLED agents over there, right out of the gate, when we first got involved in September of 2021, and one of the things that we uncovered was that Mr. Flemming had been stealing checks from his clients going all the way back
to 2012. All the way back to 2012. So when Mr. Flemming tries to tell this court that, okay, I stole a little bit, but I really was hoodooed by Alex Murdaugh as to the big money, I'd ask the court to consider that and consider this entire chain of conduct and whether or not that makes common sense and whether or not that fits with the evidence. Your Honor, what we see at the beginning of this case, the Pinckney wreck occurred back in 2009. And it resulted in terrible injuries to members of that family, injuries that ultimately contributed to Hakeem's death, injuries that Miss Pamela Pinckney, is still dealing with to this day. And what the evidence revealed is that Mr. Flemming knew how to interact with his clients. Early on, he's interacting with Miss P. He's developing that personal relationship with Miss P that you expect a lawyer to do in a case like this. He knows how to do it. But then what we see is at the same time where he's telling Miss P he's taking care of her, he's spending time with her, he's going to her hospital bed. It doesn't take him long to steal a couple of checks so that he and Alex Murdaugh can fly in a private plane and go to the College World Series. And he bills that. No one else did this. This is in his records from his law firm. He bills that to Crosswind as if it is a medical expense. And it was a private plane ride to go party with Miss P's money. And so when Mr. Flemming tries to tell you that he didn't really know what was going on throughout this entire decade-long stream of conduct, I would ask Your Honor to take that into consideration when you look at what he really did and how long it's been going on. He dispersed a large sum of money to Miss Pinckney the right way. And there is no better feeling, I am told, for a plaintiff's lawyer or their staff that when they get to call in that person who's been hurt, who's suffered, and say, I know you've been hurt, I know you've been suffered, but I've got a check of life-changing money for you. Here it is here today. And in fact, that's how usually the scheme works, because those clients, those victims are so distracted by the big check in front of them that they're not paying attention to the sleight of hand behind. And that's what Mr. Flemming did with his law license. Mr. Flemming stole those Crosswind checks in 2012. And one of the facts I have to reiterate for Your Honor is we mentioned another civil action in which Mr. Flemming was not actually the defendant, but he pretty much was the defendant because it was a close family member who was the defendant. And what the investigation revealed was that Mr. Flemming, as essentially the defendant, was doing the legal work in the case, and they were essentially using Alex Murdaugh's name as the plaintiff's lawyer. To the point where there is an email where Mr. Flemming sends to Alex Murdaugh's staffer the petition and the order with the settlement in there and says, hey, I need you to send it to the defense lawyer so it doesn't look like it came from me. And this man wants to try to convince you that he didn't really know what was up in his dealings with Alex Murdaugh. Ultimately, in that case, Your Honor, the order that was submitted, the settlement, reflects $48,000 in legal fees that were supposed to go on the paper to Alex Murdaugh. But instead, they ended up in the pocket of essentially the defendant and his family. And that's ultimately how the state grand jury figured it out, because we saw this $48,000 reference, but no $48,000 check coming into the PMPED law firm. But does it sound familiar, Your Honor? Again, I would ask you to consider that it was essentially Satterfield in reverse. Except this time, Mr. Flemming was the beneficiary as essentially the defendant of receiving monies that were supposedly going to the plaintiff and the plaintiff's counsel. Your Honor, That was going on 2012 through 2014, around the time that Mr. Flemming first stole from Miss Pinckney. And years go by to all the way to 2017. And Mr. Flemming still has money belonging to Miss Pinckney in his account. Money that he had retained supposedly for satisfaction of liens. But what we found, what we uncovered, was that was a perfect delta of money. Because once you settled those liens, or you just don't even settle them at all, that's money then that you can steal or steal from. And in 2017, Mr. Murdaugh cuts a check for $4,560 and delivers it to Alex Murdaugh, or causes it to be delivered for fake expenses of Miss P's money. Again, when you consider what he's trying to convince you, think about the entire course of conduct here and how these two men operated together. But more importantly, he also cuts a check for $89,000, over $89,000 of Miss P's money, and cuts it to PMP, and Alex Murdaugh promptly converts it to Forge. This is a man, again, who knew how to interact with Miss P, who had interacted with Miss P, who had sat by her bedside as she suffered from the injuries of that wreck. Does he call up Miss P in 2017 and say, "Great news, I got $89,000 more of your money"? Does he call up that client that he had that personal interaction with? No. He just gives it to PMP&D, gives it to Alex. Makes no effort to contact her. Again, when we look at this entirety of these events, and Mr. Flemming tries to tell you, okay, I got caught red-handed stealing a little bit, but I didn't know about all this other stuff. It doesn't fit with the evidence. It doesn't fit with common sense. But if we had any question, and we're going to get to the 3 checks in the Satterfield matter. There were 3 checks. There were one check for over $400,000 that Mr. Flemming made out from his trust account to just the single word Forge, which in and itself is ridiculous. Just the word Forge. A second check for over $2.9 million. This is money that's supposed to go to this family right here, Your Honor. Made out to the word Forge. And a third check for $118,000 made out to the word Forge. All of that money was supposed to go to this family, and it doesn't. Mr. Flemming, I believe, wants to convince Your Honor that when he cut those checks representing the proceeds that were supposed to go to this family and caused those to be delivered to Alex Murdaugh, made out to Forge, that he didn't know that Alex might take any of that money. That he thought every penny of that money was going to go to those boys. And it doesn't make sense. It doesn't make sense with the history here, and it doesn't make sense with the specific evidence in this case. And let's talk about the first thing that we have. Aside from just, it doesn't make common sense. It doesn't make common sense to make out a check just to the word Forge. It doesn't make sense because Forge doesn't take money in the traditional sense. It doesn't make sense because his own staff testified that Mr. Flemming did everything differently in this case. It doesn't make sense because Mr. Flemming, unlike we know how he does to do with Mr. P, never made an effort to talk to the Satterfield family. Never made an effort to find out if they got their money. Never contacted them, never called them up and said, "Great news." Never told the PR that they pretty much brought in as a patsy to do that either. Never told him what to do. And I'll talk a little bit more about that in a second, Your Honor. In December of 27, though, if we had any illusion that Mr. Flemming, when he cut those checks to Forge out of his trust account, when he received the settlement money in his trust account, that that's not how you do a structure, we have that email that I detailed for Your Honor, where Michael Gunn at the legitimate Forge explained to Mr. Flemming and his staffer, you received the money, we can't set up a traditional structure.
What year was that again?
That was in December 20th, 2017 was that email, and that was State's Plea Exhibit number 5, Your Honor. And I have another copy of the plea exhibits, if Your Honor, I don't know if Your Honor has them.
Yes, sir, if you would.
I'll pass those up. That was December 2017. Just a few months later, in February of 2018, Gloria Satterfield, a longtime housekeeper for the Murdaughs, fell at Moselle and suffered injuries from which she ultimately succumbed on February 26, 2018. And Your Honors heard evidence that not long after that, Alex Murdaugh told the Satterfield family that he was going to take care of them. He was going to make sure that they got taken care of for their mother's death, for her long service to that family. And who did he bring in? His longtime co-conspirator, Cory Fleming. But Cory Fleming only met with them once or twice, if that. Met with them a couple times. He never had them sign a fee agreement, which is common practice, as Your Honor knows, required practice. He never updated the Satterfields on the status of the case. He never advised them about the recoveries. He never advised them of the settlement offers. He never advised them that money was being directed to Forge. He never, of course, told them that he and Mr. Murdaugh, as I'll detail, were dipping into their money for their own personal gain and expenses. And what's most important, Your Honor, is Mr. Flemming never told this family, never told Chad Westendorf, the PR that they put in as a patsy, what he's going to try to claim to Your Honor now, that he generously cut his fee in half and had no idea that Alec was going to take any of the other half of that fee. That's what he's tried to claim now. Cut his fee in half and never once tells the PR that. Never once tells them that. You know what kind of lawyer I am? I'm going to cut my fee in half. $600,000 is enough for me. And why doesn't he tell them that? Because he's got an arrangement with Alex Murdaugh, and all the evidence in this case reflects it. It works out to be just like a fee split you see over and over again. And the reality is, the reason is because they co-litigated the case. Alex Murdaugh functioned as co-counsel with Cory Fleming, co-plaintiff's counsel in a case where Alex was the defendant. It was a shakedown. Plain and simple. These boys, this family, deserve compensation. But they were nothing but a vehicle for Mr. Flemming and Mr. Murdaugh to steal money. Again, looking at common sense and what the evidence reflects. But in November of 2018, there's two policies, one for $500K, Lloyd's of London, and they pay on the policy. Well, guess what? At that point in time, Tony Satterfield is the PR of the estate. That's Mr. Flemming's client. Does Mr. Flemming call up Mr. Satterfield and say, Tony, great news, they tendered the policy limits, first check's in, $500K, $500,000? No, he does not do that at all. In fact, he, and we have the email, instructs his staff, hold this check until we can get the PR changed. Hold this until we can get the PR changed. Why in the world did he do that if he thought that that money was legitimately going to go to those boys? It's not. It was meant to put in the patsy so they could cover up what they were about to do. And the evidence is clear, Your Honor. That states plea exhibit number 6. In fact, they get the check. Lloyd's of London cuts that check on December 4th, and they make it out to Chad Westendorf. He hasn't even been designated as a PR yet. They haven't even changed it yet. They already get the check made out to Chad Westendorf. And Westendorf was clear, and the evidence is clear, that he was not instructed what to do. In fact, he was always told by Mr. Flemming, I got it, I'll handle it. Do I need to do anything? Do I need to open a bank account? No, I got it. I'll handle the disbursements. That's not Alec, that's Mr. Flemming saying that, according to the evidence gathered in this case. In December of 2018, Mr. Satterfield is convinced by Alec to sign over being PR of the estate so that this scheme can take effect. And an order is filed that retroactively says the date was back in March of 2018, which is a fabrication.
What date was that again?
December 18, 2018 is when the PR change is issued. That's plea exhibit number 7. And the date in plea exhibit 7, if you look at that document, says that it was effective from March 28, 2018. Again, plea exhibit 7, Your Honor. Complete fabrication. Chad Westendorf hadn't been contacted back in March. Tony was the PR. This is all after the fact to hide what they're about to do. And so when he says he thought that that check that he cut to forge, which he cut shortly after this, for $403,000 was actually going to go to an account for those boys, aside from the fact that that's not how it works, and it makes no sense, and it's made out to a single word forge, it's all an after the fact reconstruction to put in their patsy so they don't know that they've gotten a recovery. And Mr. Flemming is at the center of that. Aside from the fact that even if he tries to claim that when he handed those checks to his co-conspirator abusing the judicial system, if I didn't know what my fellow thief was going to do with it, that's not even good enough under the law anyway. When you're conspiring with somebody, you're responsible for the natural and probable consequences of that act regardless. But even that being the case, he knew, and the evidence is clear. I want to be clear. The state has never contended that Mr. Flemming thought that Alec was going to steal every single dime. Because that's not usually how the scheme works, right? As I just stated, you're usually handing some big check, life-changing money to people who've never had that kind of money before, and they're so distracted by that they don't realize you're stealing right from behind them. But for Mr. Flemming to claim that when he delivered those forged checks representing the vast bulk of all this money, that he thought that every dime was going to go to those boys, it defies common sense, it defies the evidence, it defies what he knew how things were supposed to work. Mr. Flemming never once communicates with Tony Satterfield about the change of the PR, never once communicates with Tony Satterfield about a recovery of $500,000. Instead, he deposits the check that they had pre-made out to Chad Westendorf even before the change of PR, and then Mr. Flemming prepares a petition for approval of wrongful death settlement and an order. And that order says that there's going to be $166,000 in attorney's fees, which is the standard percentage. But that's not what happened. It also has in there, on the nose, $11,500 in expenses, which are completely fraudulent. Didn't exist. And what Mr. Flemming's own staff revealed is that in the Satterfield case, every step of the way, normally when they're preparing the disbursement sheets, they're getting all the receipts from the expenses, depositions, travel, mediator expenses, all that. She's getting them all together and she's itemizing them and doing all the math for that disbursement sheet for the client to sign. And instead, no, stop. This is the numbers I want you to put down. That was Mr. Flemming doing that, not Alex Murdaugh. That's plea exhibit 9, Your Honor. January 7th, 2019, they get Chad Westendorf to sign a disbursement statement. Again, it's got those fraudulent expenses of $11,500 on there. This time it does indicate that the attorney's fees is $50,000. Again, cutting the fee, but never telling anybody, telling Mr. Westendorf, hey, let your clients know what a great attorney I am. I'm cutting my fee in half, or less than half. Out of the goodness of my heart. Never says that. What does that tell you, Your Honor? Why would somebody do that and not let the people who are supposedly benefiting from that know? The only reason you're doing that is because you're creating a delta for your co-conspirator to steal. Mr. Flemming, when that check gets cut, Mr. Westendorf's like, what do I do, man? Tell me what I need to do. And he says, I'll handle the disbursement. Mr. Flemming does. I'm going to pay some medical expenses, which he never does. Absolutely never does. January 17th, 2019, just a week later or so. That first money has come in. It's in Cory Fleming's trust account. And this is the first evidence where we see Mr. Flemming be like, yeah, that's a lot of money. I think I'll just go down and take some of it. And he goes down to a staff member and says, cut me an $8,000 check made out to me from the trust account of money belonging to this family and say it's expenses for the case. They're completely fraudulent. We can look at Mr. Flemming's accounts. He may not remember why he did it, but we can see why he did it. Bank records tell a story, and we can see the balance in his account, how low it was, and we can see that money come in, and it immediately goes to pay a mortgage and other personal expenses. Needed the money, had their money, and just walked down to a staffer's desk and said, cut me a check. And stole it. Ultimately, there's a mediation. Mr. Flemming is there, and Mr. Murdaugh is there, and ultimately they collude during the course of that. And Mr. Murdaugh is like, Bo, I got to get me something out of this. I got to get me something out of this, Cory. They accept an offer, settlement offer for $3.8 million. Does Mr. Flemming tell this family about such a momentous event? No. Does he try to communicate with them? No. Does he tell them, oh, I got y'all $3.8 million. I can take $1.4 million in fees from that, and I'm going to cut it in half out of the goodness of my heart. Does he do that? No. Why? Because he is creating that delta for his co-conspirator. Because they have the patsy in there so that they can get the scheme done. And they tell Mr. Westendorf again, we got it. Mr. Flemming says to Mr. Westendorf, I'll take care of the disbursements. $3.8 million come in. That's a big day. And Mr. Flemming doesn't wait a moment, because on March 26th, he goes right back down to his staffer and says, hey, cut me a check for $8,500 for expenses in the estate of Gloria Satterfield, which are completely fraudulent. Couldn't wait one day. Let me go ahead and put $8,500 in my pocket. And again, we can look in his account and see how low his balance was, and we can see immediately the vast majority of that money he has to make a payment of taxes. Again, there's no illusion about the motive here. He was broke and he needed the money, so he just stole it from this family because he had it in his trust account. Well, they got $3.8 million. And again, if you have any illusions about Mr. Flemming believing that when he cut those checks to Forge, that $2.9 million check, which is the next check that he cut to the single word Forge, that he really thought that every dime of that money was going to this family, well, the emails prove otherwise. And these are crucial, Your Honor, States Exhibits 13 and 14. Because the adjuster at Nautilus is like, I don't understand. What? Tell me how to cut this check. Is he doing a structure or not? But does he want to a single check? We need to know, because if he's going to do a structure, he has to do it this way. And Mr. Grantland sends it to Mr. Flemming, says, what do you want me to tell him? And Mr. Flemming's like, well, says some things. He's like, well, I got to check with Forge, which is a lie, because he's not dealing with real Forge at all. And they don't have an answer. So, again, Mr. Grantland sends the same question that the adjuster from Nautilus is saying, how are we cutting this check? This is the email. I need some clarification here. If he has a structure, don't we need to wait for information on the structure? Is he wanting us to fund the structure? Or is he funding the structure? If he wants us to fund the structure, it must go through Ringler. If he doesn't want us to fund the structure, does he want the funds to consist of a single check in the amount of $3.8 million payable to Chad Westendorf as PR? And the Nautilus attorney forwards that to Flemming and says, let me know what I need to tell her. And eventually, on April 1st, 2019, Mr. Flemming says, okay, standard check. Chad Westendorf as PR and MK&F as attorneys. There was no structure, and Mr. Flemming knew. Aside from the fact that's not how it works. He couldn't take the money directly. You can't do a structure in the traditional sense that way. These emails prove it. He tells them standard check. And of course, that check is cut to his trust account. And May 9th, 2019, Mr. Flemming tells the Nautilus attorney, you don't have to come to the hearing. And then, Your Honor, this is State's Plea Exhibit 18, and this is a crucial thing as well that refutes Mr. Flemming's claim that he was only doing 58 miles per hour. Because again, his staffer starts to prepare a disbursement sheet, and she's searching for legitimate expenses, and she puts on there that there were disbursements to Forge for Lloyd's of London of $403,500, and there's disbursements to Nautilus of $2.9 million in change, and also puts on there the fees. And Mr. Flemming, not Mr. Murdaugh, Mr. Flemming goes down and tells his staffer, no, stop, don't do it like that. Put these numbers down. Without any support, just tells her, no, I want these numbers. And that's in Plea Exhibit 19. And what's crucial about that, Your Honor, is that any reference to Forge is removed. In the one they actually give to Chad Westendorf. It's removed. And what's also crucial about that disbursement statement, Your Honor, State's Plea Exhibit 19 that they give to Chad Westendorf to sign is that it's got the full fee, collective fee between the two recoveries of $1.4 million on there. It lists that they're taking the full fee. That's what he tells the PR. He doesn't tell the PR, oh, by the way, out of the goodness of my heart, please tell the boys, I'm such a great lawyer. I'm so generous. $600,000 is enough for me. Cut it in half. He doesn't do that. No, he puts the entire fee on that. And why does he do that? He does that to create the delta for his co-conspirator to get his half of the fee split. There's no other reasonable explanation, Your Honor. Particularly when you look at the entirety of the course of conduct of these two men together. So, Mr. Flemming takes his fee of $600K for Nautilus and $50 for Lloyd's, and then causes that check to be made out to Forge and has it delivered ultimately to Mr. Murdaugh. That's in May of 2019. A number of months go by, and they still have money that they've retained belonging to the Satterfields. Mind you, the Satterfields don't have a dime. The Satterfields don't even know that one solitary cent has been recovered on their behalf. They don't know any of that. And over $4 million has been recovered in their behalf, and no one has told them a thing. Certainly not Mr. Flemming, whose responsibility it was. And he can't hide behind the fact that, oh, well, I was dealing with Chad Westendorf because he specifically didn't tell Chad Westendorf what to do, and he specifically participated in conspiring to put Chad Westendorf in there as PR as a patsy to keep the truth from coming out to these boys and this family. But Still got money in the trust account. Mr. Flemming needs some walking around money. So January 2020, goes on down to a staffer and says, hey, cut me a check for $9,700 out of the Satterfield money from the trust account. Make it again payable to me. This time he didn't even, it's gotten so easy, he didn't even bother to try to put on their expenses for the estate or anything like that. There's just no justification. Just cut me a check out of it. $9,700. And he spent that money on personal debt. Again, if we have any illusion about what Mr. Flemming knew when he was colluding with Alex Murdaugh, or that he really thought that this money was going to the family, despite this entire course of conduct that was specifically designed to keep them from knowing a thing, there's still money in the account. 17 months go by, Your Honor. In October of 2020. And a couple things happen. The first thing is that Mr. Flemming signs a stipulation of dismissal for the case. And do they involve the Nollis attorney? Does he sign it? No. The only other person that signs it is Alex Murdaugh, the defendant himself. And concurrently with that, at the same time, the next day, October 6, 2020, he causes another check to be cut from his trust account made out to the single word Forge for $118,000 and has that delivered to Alex. Now what's interesting, Your Honor, is that when we look at that $118,000 and then actually there was still $113,000 that was remaining in his trust account when all of this stuff came to light, it totals $231,000. Which in their sentencing memorandum, they admit, they attribute that to Mr. Flemming. But how in the world can they attribute that $118,000 in October 2020 when he disperses that to Alex to Forge and they sign that stipulation of dismissal with the defendant himself? How can he say that he knew that that Forge check was bad but not the other Forge checks? The whole thing stinks to high heaven. The whole thing is done underhanded. The whole thing is done to prevent the system from knowing what was going on and to prevent this family from knowing what was going on. It was designed that way, and he was part and central to it, crucial to it, from the very beginning. Mr. Flemming might try to tell you, or his counsel, that when everything came to light, he was appalled. And eventually, as everything came to light, and actually after requests were made or demands were made, disgorged his fee. Well, Your Honor, you don't get to rob a bank, run down the road, and the police catch you and say, oh, here's the money back, we're cool, right? It's not how it works. And what he didn't do was say, oh yeah, by the way, I've been stealing checks from these accounts for almost a decade. He didn't come clean with that. It took the state grand jury to catch him red-handed for him to finally recognize that he was caught. And he could no longer claim to be, like so many other people, yet another poor, unfortunate victim of Alex Murdaugh. No, he was the co-conspirator. Your Honor, when we total up the losses attributed directly to Mr. Flemming's conduct in this case, between the Satterfields and the Pinckneys, that total is $3,725,203.85. And everything about this case and how it was done shows you that his Johnny-come-lately mitigating, I'll only admit to what, the very minimum, I'm only was doing 58 miles an hour, everything about this course of conduct refutes that. Aside from, Your Honor, just good old plain common sense. Common sense about how this was done. I'd like at this time, if it's acceptable to the court, to let some of the victims address the court, and then I'll have a few more comments before I will yield to the defense presentation. And I will also request the opportunity to speak after the defense presentation to address any issues they may raise. But at this time...
Very good. Before you do that, let's all just take a moment to
Yes, sir.
stretch for a moment. If everybody will take a moment. Stand. Came from St. George. We were in Barnwell. I thought the reporter said she was coming down last night. Was she? Yeah.
Yes, I don't know. I just
Yeah.
received that.
She was leaving Barnwell yesterday to come here. Notice. But you. Sure. Okay, we'll come to order.
Thank you, Your Honor. With the court's permission, I believe our first victim who would like to address the court is Mr. Tony Satterfield.
Okay.
My name is Tony Satterfield. So first, I just want to say this is actually a life lesson to everybody. You know, a lot of times, we think our actions do not affect other people, but they do, bad and good.
Mr. Satterfield, if you will address your comments to me.
I'm sorry.
Yes, sir.
Second thing I'd like to say is that my answer still stands. I still forgive Mr. Flemming. And as far as the sentencing goes, that's left up to you, Your Honor. That's why, you're in this situation to give that, not myself. And the main thing, I know I'm going to get asked, well, what do you think? How do you think it went? Me personally, my honest answer, I don't care. I just want God's name to get the glory for it. I just want, His name to be known.
All right. Thank you.
Junior Hadwin, Gloria's sister.
Good morning.
First of all, I would like to say that our family, of course, was affected in a tremendous way that hurt us deeply because we not only trusted the system, we thought what was family to us. And yes, Mr. Flemming did wrong and he admitted what he done. And yes, he should be punished for what he's done. But we do forgive. As a Christian family, we believe in forgiving. But it still does not take away the hurt that he caused us. And also, we feel like Gloria did not die in vain because her case actually brought out a lot of other corruption and dishonest deeds that were done to other people. And we feel like that it is being served now. Things are coming to light that should have been brought to light a long time ago. And I want to thank the state for all the work that y'all have done to bring everything to light. And Mr. Wardage, you've done a fantastic job this morning, bringing out everything and actually simplifying a lot of stuff. And thank you very much. Judge, thank you so much. We trust in you and your honor that you will make the right decision in your sentencing. And again, we do forgive Mr. Fleming.
Thank you.
Thank Eric and Ronnie also.
Judge Newman, my name is Eric Bland, and I have the honor of speaking on behalf of the Satterfields.
Yes, sir.
I also have the honor of speaking as a lawyer of 35 years on behalf of other lawyers. Lawyers who are overwhelmingly honest and do good by their clients. The license we have is a sacred trust. It's a trust that we have to help our clients. It's not a ticket or a license for us to take from our clients. And, you know, it's natural that we want to dislike criminals. We want to dislike people like Mr. Flemming. But you're going to hear from a courtroom of people that he's a nice guy. But unfortunately, nice guys sometimes do criminal activity. And so you have to balance today not only the sentencing of a man, but sentencing the crime. Because our profession, a profession that I love, a profession that you love and dedicated your life to, has been stained. And you understand that when things like this happen, when lawyers take money from their clients, especially in this case when it's millions and millions of dollars, that the jokes multiply by 10. I've never liked lawyer jokes. I don't like people mocking lawyers. I don't like the nasty things that sometimes that people say. But one criminal activity in this type of case germinates and hurts our profession for a long, long time. Now, I think it's important that you do understand that Mr. Flemming knew exactly what he was doing. He is a plaintiff's lawyer. He has settled plaintiff cases before. And in this particular case, he worked with the party he was making a claim against. It's impossible to get your arms around that. He didn't have client permission to do that. He never had a fee agreement to do what he did with the client. We know, and Your Honor knows, the contingency fee agreements have to be in writing. There was no contingency fee agreement. There was no joint sharing agreement with Mr. Murdaugh, even though he couldn't do it to begin with, to disclose to the client. There were no disclosures at all to the client. He met Tony Satterfield as the PR one time. There never was any communication. I've been suing lawyers for probably 30 of my 35 years. I have never seen every single dollar taken from a settlement. You see sometimes that it's, you know, a portion of it. But in this case, they took every single dollar and never communicated with Tony Satterfield, never communicated with Brian Harriet, his brother. They recovered millions of dollars. They should have been applauded for recovering that on behalf of Gloria Satterfield. You're going to hear that Mr. Flemming said he won't use the word victim like he used for the last 2 years, where he said that he was a victim just like everybody else. But you're going to hear kind of off words that are close, maybe a first cousin of victim. You're going to say he didn't understand what was going on. Sure he did. If you're going to do a structure, Your Honor knows that you have to have insurance policies that represent that structure. Your Honor knows that when you have two beneficiaries of that structure, there would be two separate policy numbers, one for Tony, one for Brian. Your Honor knows that if you're going to send a check to the structured insurance company, you got to allocate. You can't just send a check for $2.9 million to an insurance company and not have any reference on the check that this amount is for Brian and this amount is for Tony, and it needs to be deposited in this account and applied to that insurance policy number. None of that was done. Mr. Flemming sent the check without a cover letter. No letter to to Forge to say, hey, this is how it's allocated. It was sent to a P.O. box in Hampton, South Carolina. Every plaintiff lawyer knows that Forge is in Columbia, South Carolina, and Atlanta, Georgia, not in some P.O. box. More importantly, the 3 checks that Mr. Waters described were signed on the back by Alex Murdaugh himself. It says, DBA, Alex Murdaugh, DBA Forge. Hey, that would give it away, right away, that he was not doing a regular structure. This is a case, Your Honor, that was really 2 letters that were sent. And, you know, magically, $4.3 million was produced. A tremendous amount of money. Not that Gloria or any other person isn't worth that, but that is a very large settlement. A settlement that would probably be 3 times larger than most other counties in our state. And Mr. Flemming took $11,500 in expenses in a case that there was no filing fees, in a case that there was no depositions, in a case that there was no experts. He had a signed disbursement sheet in May of 2019, signed by a judge, just like you. And when you sign an order, we have to follow it. But he took that order, and he never filed it with the clerk of court, despite getting a letter from the insurance company that said, before you disperse on that check, make sure you get a signed order and file it. But what did he do? He didn't file it. What did he do? He went into the chambers of Judge Carmen Mullen down here, and he told her, look, we've made a decision to change the caption on the case. Instead of it going to be the estate of Gloria Satterfield decedent versus Alex Murdaugh, we've decided to take Mr. Murdaugh's name off the caption. No, I can't do that without Your Honor's permission. But that was done without a court order. And then they took off Gloria Satterfield estate and decedent to make it look like she wasn't even dead at all. And what did they do? They came back after they got that signed order, after they told Judge Carmen Mullen, this is how we're going to disperse it. There was no reference that they were going to send $2.9 million of the $3.8 million to Forge. They were going to disperse it to Brian and Tony. What did they do? They just totally disregarded that order and started cutting checks, a check cutting party on May 14th. No court permission. You know, if I'm going to deviate from the order you signed from the disbursement sheet, I better come back before Your Honor and do that. No permission from the court was done. Nothing. No communication with these clients. This young man here, who's a vulnerable adult, who's in his 30s, lost his mother. Alex Murdaugh and Cory Fleming knew that his trailer was being foreclosed on, and he didn't have the money. And they're sitting on $4.3 million of their money while he's getting pushed down on the street and loses his mother's trailer. That was all she had. That was all she had. What happens? He keeps money in his trust account. Judge Mullen signed an order that said, you disperse every single penny in your trust account. As Mr. Woodard said, he kept it for 18 months in a case that was over with. In a case that he went before Judge Mullen and said in May, I need $105,000 of additional expenses that we spent. That's going to be dispersed. Again, in a case that no lawsuit, no depositions, no expert witnesses, and it was $105,000, not $105,172.27. It was just blatant thievery in open eyes of everybody except the 2 most important people that we work for, the clients. And what happens? Like Mr. Woodard said, on October 12th of 2020, 17 months later, they decide we're going to cut some more checks. And you know what? We better get this case off the docket. So Mr. Flemming and Mr. Murdaugh decide to sign a stipulation of dismissal. Mr. Murdaugh had a lawyer, John Grantland, who represented an Nautilus insurance company. He wasn't contacted. Mr. Flemming knew that there was a lawyer involved. and they dismissed the case. Yet he sits on another $113,000 for another year, all the way up to the fall of 21, when he finally was caught, when I finally surfaced on September 7th with my partner, Ronnie Richter. Now, I will say this. Of all the defendants that we got money for, and we can announce that we've recovered more than $7.5 billion for the Satterfields from a number of sources. Mr. Flemming was the first to come forward in the fall of 21. He did disgorge himself of the $680,000. His insurance company did pay the full value of his policy. He did finally disperse the remaining $113,000 in his trust account to my clients, and there was additional monies paid by his law firm. But the last thing I want to add, Your Honor, is he fought these charges. He wrote a letter to the Georgia bar. Now, unlike our South Carolina bar proceedings, the Georgia bar proceedings are open. I was a complaining party because whenever I bring a claim against a lawyer for malfeasance or theft, it's my duty to notify the bar, and so I notified South Carolina bar and notified Georgia bar. So I'm part of the process in Georgia. They want to hear from the complaining party. So when Mr. Flemming filed his response to the Georgia bar complaint, I got it. It was a 57-page response that he did under oath. Swore to tell the truth, just like he's going to do when he stands before you today. You know what he told the Georgia bar? I was a victim of Alex Murdaugh's theft. I had no idea what he was doing. I was duped just like everybody else. I didn't understand how to do the structure of Forge. Mr. Wooders shared with you that February 2017 letter. It was crystal clear. And he had already done structures, but even if you haven't done structures, it says you can never get the check as the settling plaintiff lawyer. It's got to go from the paying insurance company to the annuity insurance company that's going to issue the structure. He already got the checks. Like Mr. Wooders said, Forge doesn't get money. They're a broker. You don't send money to Forge. It goes to an insurance company. But in that 57-page response, he says, I had no idea what was going on. He didn't, you know what he said? I stole from my law partners. I didn't steal from the clients. When I stole those 3 checks of the $9,500, the $8,500, and the $9,000, I was stealing from my law partners. By the way, Judge, you read the rules of professional conduct. We don't have a license to steal from our law partners either. That's another no-no. So, I know you're a just judge. I watched you. I've watched you your entire career. I know how much you care about what our profession. I certainly know how much you care about our state. And this whole Murdaugh, Flemming, Laffitte debacle has stained our state. And I'm going to leave with saying one thing. The hand of one is the hand of all. And Mr. Flemming is pleading guilty to every single charge, which means every single element of every single crime and every single fact that Mr. Wooders has announced form the basis of those. So I ask you to do your duty, to look at this as these are state court independent charges, not to look at, well, he's been sentenced in federal court, so that kind of takes care of it. These are claims that our citizens, the state of South Carolina, brought through a grand jury, advanced with our dollars through the South Carolina Attorney General. And I'm confident that at the end, you will give that proportionate, just sentence that deals with retribution to punish Mr. Flemming appropriately, but not overly so. Deterrence to tell me and every other lawyer, you cannot steal from your clients. Your duties are to your clients, not to yourself. Thank you.
Thank you.
Your Honor, I think our final victim presentation before I conclude my initial remarks comes from Mr. Bamberg, who again represents Pamela Pinckney. And I think it's important to point out that while there has been a resolution in federal court, that was only on indicted Satterfield conduct because of the statute of limitations there. And I know that Mr. Vanberg will address, of course, that we are here today for the first time for accountability as it relates to Ms. Pinckney alone. But Mr. Vanberg, I'll turn it over to you.
Thank you, Your Honor.
Yes, sir.
Creighton is correct, Attorney Waters is correct. On behalf of Ms. Pinckney, she wanted to be here, but she had a procedure on Monday, a medical procedure, and she's been dealing with a lot of pain since. So I'm here on her behalf, and that really speaks to the type of people who were victimized. We had to sit through a federal case through the United States of America's court system and hear about things that were done to the Satterfields. And Ms. Pinckney, her family supports the Satterfields. What happened to Ms. Pinckney, what Mr. Flemming did to Ms. Pinckney was mentioned in the federal case. However, due to statute of limitations, she was not able to seek justice, criminal justice through that. That's what today is for. It's her first opportunity after well over a decade. Your Honor, I want you to understand a little bit about what Ms. Pinckney went through. When we think about white-collar crime, a lot of times people talk about it as though it is victim bliss, that it just involves the almighty dollar, and that's not the case. This was a horrendous accident. Not only did Ms. Pinckney shatter most of the bones in her body, it was a very extensive recovery process for her. But she had to deal with injuries to other people that she cared about. For example, her niece, who in addition to numerous physical injuries, lost the vision of one of her eyes. And her son, Hakeem Pinckney. And Hakeem, Ms. Pinckney poured her soul into that young man. And he lost his hearing at 3 years old. He struggled with that. And she never gave up on him. She poured into him. He ended up graduating from the South Carolina School for the Deaf and Blind. And shortly after graduating, he had all these dreams and ambitions. And during that accident, that fateful day, this young man was rendered a quadriplegic. He was unable to move anything below his neck. He was on a ventilator to breathe from him. He relied on an electric machine to breathe from him. And because he couldn't move, he couldn't sign language, and therefore he could not verbally communicate. And she never gave up on him. Hakeem died, and it was very tragic. His ventilator was found unplugged. So, and it's hard not to get teary-eyed when you think about what he went through, but here's a young man who cannot hear, he cannot speak, he cannot move, and now he cannot breathe, and he can't tell anybody. He became a prisoner of his own body. And Ms. Pinckney was aware that that is how her son died. And instead of being a supportive lawyer, instead of showing compassion and care, empathy or sympathy, he could have said to this woman, I am so sorry for what you went through. I want to own up to the fact that I took some of your money. No, he didn't. In fact, they took the money and they flew to the College World Series to watch baseball. Meanwhile, this woman is still recovering. She's still dealing with the loss of her son. And no one cared. And I've said this before, Ms. Pinckney, myself, the Pinckney family, everyone believes that Mr. Flemming regrets everything that he did, not just to them, but to the Satterfield family over a decade later. Nobody doubts that he regrets it. It's hard to not regret your decisions when you're sitting there. I think everybody regrets that except complete sociopaths. We do not believe that he is remorseful for what he did. And there is a difference between I regret getting caught and getting in trouble and true remorse for what I did to you. When we hear these numbers, Your Honor, and we hear numbers like $500,000, we hear numbers like $3 million, we hear about total amount of money stolen, we have to remember that where we come from, and myself, Ms. Pinckney, that I'm talking about geographically, where we live, we're $8,000 check, $9,600 check. Yes, for privileged attorneys and others who either have been very blessed, very successful, or work very hard to get there, it may not sound like a lot of money when you hear about $4 million get taken. Minimum wage in our state, Your Honor, $15,850 if you're making minimum wage. That's how much you earn working for a year. Some of the money that Ms. Pinckney lost, she would have to work over half a year to earn and then pay taxes on it. This is not a small amount of money. This is not a victimless crime. Your Honor, we trust the system. And I echo much of what Eric Bland said, that this was a black eye to attorneys. It was a black eye to the legal profession. It was a black eye to our state. But it was a dagger in the heart of the clients who trusted their lawyers. Mr. Flemming knew he wasn't supposed to do it. We firmly believe, and I've had in-depth conversations with Ms. Pinckney about this, it wasn't until the federal government came, and now there was this window of opportunity to possibly serve a sentence in federal court, that Mr. Flemming was then willing to say, yes, I did X, Y, Z. Up to that, there was no, yes, Ms. Pinckney, I took your money. That wasn't represented to the ODC ethics, as you heard Attorney Bland reference. It was deny, deny, deny. And one of the most difficult things for Ms. Pinckney and every other victim is having to know that you are truly a victim of bad acts from bad actors, and then hear those same bad actors who took bad acts say that they're a victim. It's demeaning, it reopens old wounds, and it's highly offensive. And in the world of white-collar crime, Your Honor, if we talk about Wall Street, it's not necessarily people stealing your money and you willingly give it to the investment bankers. No one willingly gave Cory Fleming their money. He deceived them. He took it. You know, and I know that there will be folks who will speak very positively about him. And we have no doubts that to a lot of people in his life and over the course of his life, Your Honor, he was an amazing person to them. He did do wonderful things to them. He was very giving to them. But he's not here today sitting in judgment of Your Honor for how good he was to everyone else. He's sitting in judgment for pleading guilty, element for element, charge for charge, to how bad he was to Ms. Pinckney and the Satterfields. And we would ask that Your Honor take all of that into consideration. This is their one chance after over a decade to get justice, Your Honor. And we ask that this court impose a sentence that is not only sufficient to, again, punish Cory Fleming. He's got a federal sentence again, but it has nothing to do with Ms. Pinckney. He has not been punished for that. We ask that you sentence firmly to not only punish him for that, but to also deter not just lawyers, but anybody who owes a fiduciary duty and people rely on you. Don't steal from them. We're not expecting people to be perfect, but we are expecting you to be a decent human being. And if you're a lawyer and you take that oath that we all have to take, that you take that oath seriously. And it doesn't matter whether you personally have hard financial times or not. The saddest part, as an attorney who's gotten to know Ms. Pinckney, Your Honor, is knowing that even with the horrible death of her son, even with her own broken bones, her own medical bills, is that Cory Fleming needed money, Your Honor, and asked her. I guarantee you she would have gave it to him. That is the type of person Ms. Pinckney is, and that is who he victimized, Your Honor. Thank you so much for your time.
Thank you.
Your Honor, I just have a few more brief comments, and then I will yield to the defense for their presentation. Again, would request the opportunity to speak and reply after they have presented. Mr. Bamberg touched on this, and I know Your Honor has been presented a lot of letters, and I know that there's support out in the courtroom for people who have known Mr. Flemming. And I'm sorry. I'm sorry to them because they've been victimized by this too, because they have to be here. And they're put in this position. And I'm sorry that they have to go through this because I have a job to do. These people on our team have a job to do. The law enforcement officers here have a job to do. And the reality is that to be a con man, it depends on trust. It depends on reputation. It depends on the inherent credibility that comes with having a law license on your wall. It doesn't work otherwise. It depends on someone who doesn't have a prior record, which Mr. Flemming does. That's how con men work. That inherent trust and reputation is what they tread upon for this scheme. It doesn't work without all these good things that people are going to say that they believed about Mr. Flemming. It's the only way a con man can succeed, is if people trust him. And they did. And he betrayed them. You might hear a little bit about the process, and you may hear essentially that the state, the Attorney General, the State Law Enforcement Division are being unreasonable because we refuse to accept and just check the box that Mr. Flemming was only doing 58. Instead, insisting, because of the hard work that was done by all these folks, to really dig deep and uncover the truth. The truth matters, Your Honor. The truth about what happened to the system matters. The fact that he was doing 90 miles an hour matters. It matters. It's not enough to just say, I did 58, and we'd say, okay, that's fine, we're done here. What really happened matters. When it affects the integrity of the system, when it was abuse of the system, of the very courtroom in which we're in right now. Your Honor, independent accountability for his abuse of his state law license and state court actions is warranted in this case. Consecutive time is warranted. Consecutive time is warranted for the extent of the reality of what Mr. Flemming did to the Satterfields, exposed in this courtroom, the 90 miles an hour. Independent accountability is warranted for that, above and beyond whatever was before. I'll give Mr. Flemming credit for pleading guilty, but he doesn't get credit for the delta, for the difference between 58 and 90 miles an hour. And his inability and refusal to admit to that, to only admitting to the most mitigating version of events that he can no longer deny because he's caught red-handed, that only should get so much credit, Your Honor, and there needs to be independent accountability for the truth of what happened to the Satterfields, above and beyond any other proceeding that has nothing to do with what happened here, or what this proceeding is. Independent accountability is warranted for Pamela Pinckney, who, as Mr. Bamberg said, has convictions relating to the conduct victimizing her in this court. And while you may hear that in another proceeding they rolled that into a PSR, that's not the same thing, and we don't even get that. I don't know what's in that thing. It doesn't matter though. A lawyer should not get one-stop shopping for victimizing multiple clients over the course of a decade. It's not buy one, get one free. There should be independent accountability here today, consecutive accountability for Ms. Pinckney. He should not get buy one, get one free. And independent accountability is again warranted for the state judicial system itself. They must defend itself and have its own independent accountability and not allow someone, when the state is unhappy with 58 miles an hour, to just make a deal and that be the end of it. I ask Your Honor for consecutive sentencing. I ask Your Honor that even if you run sentencing for the Satterfields concurrent to anything else that happened, that any sentence for the Pinckneys be consecutive. I ask Your Honor not to let Mr. Flemming, who I think we have established has not completely come clean with the reality of his behavior and only admitted to what he's admitting to now because he got caught red-handed.
What is his exposure for in the Pinckney case and the Satterfield case?
Stand by, Your Honor. So the total exposure between the two is 195 years and fines up to over to $8,090,863.90 plus discretionary fines. Your Honor, if we look at the Satterfield crimes, count 10 is a criminal conspiracy, which is 0 to 5. We have 3 counts of insurance fraud, $50,000 or more, which is 0 to 10, plus fines of $20,000 to $100,000. Counts 13, 17, 21, and 30 are breach of trust with fraudulent intent, $10,000 or more, which are 0 to 10, plus fine in the discretion of the court. Counts 14, 18, and 22, value of money laundering, value $100,000 or more, carry a potential sentence of up to 20 years, Your Honor, and a fine not to exceed $250,000. Counts 23, 25, and 27 are breach of trust with fraudulent intent, value $2,000 to $10,000. That's 0 to 5 plus fine in the discretion. Counts 24, 26, and 28, 3 counts of money laundering, value $300,000 to $20,000, which is 0 to 5, and or fine not to exceed $250,000 or twice the value of the transactions. And then count 29 is computer crime, value more than $10,000, which is a 0 to 5, and or fine not more than $50,000. Your Honor, that is the Satterfield case. For the Pinckney case, 2022 GS 4702, again, both of these indicted by the state grand jury back in early 2022. We have counts 5 and 9, which are breach of trust with fraudulent intent, $2,000 to $10,000, which are 0 to 5 plus fine in the discretion, or fine in the discretion. Counts.
You say 0 to?
0 to 5 or fine in the discretion for that one, Your Honor. Count 6, breach of trust, $2,000 or less. That's actually a 30-day offense, Your Honor, or a fine not more than $1,000. That would have been one of the crosswind checks, which was like $1,400. Count 7, which is criminal conspiracy, that's 0 to 5. And count 8, breach of trust, $10,000 or more, which is 0 to 10, or fine in your discretion. Again, the state would submit that no matter how you stack them, even if you run certain ones together, that there needs to be independent, consecutive accountability from one to the other. And that there needs at a minimum to be a lead sentence for the Satterfields and a consecutive lead sentence for the Pinckneys. So that Mr. Flemming, for decades, almost a decade's worth of conduct, doesn't get buy one, get one free. Thank you, Your Honor.
All right. Ms. Barbier?
Thank you, Your Honor. May it please the court.
Yes, ma'am.
Your Honor is aware that on August 21st, I filed with the court an initial sentencing memorandum, and in that sentencing memorandum laid out for Your Honor some of the background of the investigation, joint and federal investigation, and then also talked a lot about Mr. Flemming's life, his community involvement, the things that bring him to you today as a whole person to look at. And then, Your Honor, following the guilty plea, which is when we heard a lot of the same information that we heard today from Mr. Waters, on September 12th, we filed a supplemental sentencing memorandum. And in that sentencing memorandum, we addressed a few of the factual issues that we had some discrepancies with. And then yesterday, I received a response from the state. And I want to thank the state because they responded very quickly. And I think that what I gleaned from their memorandum is there's very little that we disagree with in terms of the responses they made to our sentencing memorandum. First, Your Honor, I took issue with the fact that they said that Mr. Flemming had invited Mr. Satterfield into his office and changed the personal representative execution forms. I pointed out the evidence simply doesn't support that, and Mr. Waters agrees with that. And we're not saying it's material to his guilt, but we wanted to point that out because it was factually inaccurate. Secondly, Your Honor, with respect to the caption that was created on the stipulation of dismissal, the petition and the order, that was not done by Mr. Flemming. Again, that's not material to his guilt, but it's something that I wanted to point out for the court was not accurate. Regarding the check that was written on the Pinckney settlement proceeds, the $89,000 check, Mr. Waters stated during his plea factual basis that had been made out to Alec personally. It was not. It was made out to the Murdaugh firm at that time. Again, that's not necessarily material to his guilt, but that was a factual inaccuracy that we wanted to point out. Most importantly, Your Honor, and I appreciate the state's candidness with the court on this issue, they, right out of the gate in their sentencing memorandum said, and I'm quoting them because I don't want to misspeak on their behalf, they said the state does not allege that Flemming necessarily knew the specific particulars of Murdaugh's fake forge account or that Murdaugh intended to steal all of the money given to him. Indeed, the state has consistently accepted that Flemming might not have expected Murdaugh to steal all of the money. And that's an important fact to Mr. Flemming, Your Honor. That's an important fact that he wants you to know, and that, again, was reiterated today by Mr. Waters in his closing argument or his fact, whatever you want to call it, that he made today. And so we appreciate those two concessions. Those are very important for Mr. Flemming to have on the public record, both for him and for his friends and supporters to understand. And so I appreciate the state's response and the prompt response of that nature. With respect to the forge issue, Your Honor, I know that Mr. Bland and Mr. Waters have made a lot of comments about what Mr. Flemming definitely knew or should have known or did know and what he did. We pointed out in our sentencing memorandum a couple of things that I think would be good to reiterate at this time. Your Honor's heard, I'm sure, a lot about forge from the other trial that you had and from the information in that trial that was put forth about forge consulting. Your Honor's probably aware that the fake forge account was created in September of 2015, which is years before the Satterfield case came to be. The account was started at Bank of America, and it was titled Alexander Murdaugh DBA Forge. The account clearly had no affiliation with the real Forge Consulting. But Mr. Murdaugh was the only authorized signer on that account. He's the only one that had access to it. He's the only one on the signature card. And unbeknownst to Mr. Flemming and to a lot of other people that Your Honor himself heard from during that murder trial, good people people that had known Mr. Mr. Murdaugh for 40 years. And the crux of the testimony, Your Honor, and I don't have to tell you because you had front seat to that trial. But the crux of that testimony was that Mr. Murdaugh habitually lied to everyone in his personal and professional life. He lied extensively to his law partners, to his accounting department, his CFO, his family, his office manager, his banks, his creditors, his opposing counsel, to judges, and court personnel. And Your Honor, during this time period, I think it should be known, Mr. Murdaugh was the president of the Trial Lawyers Association. He was by many accounts, a respected member of the bar, and a lot of people, including Mr. Flemming, were stunned to find out that he had been stealing millions of dollars, diverting it into this fake forge account. Ms. Seconder, I recall, her testimony was that the firm had these checks being written to forge for years out of their trust account, and they didn't know he was stealing. There were the bank statements from the fake forge account were in Mr. Murdaugh's office. No one caught that. No one caught the fact that these checks were coming back with his individual signature on it. Mr. Flemming never saw those types of checks come through his office. I cited to the testimony of Mr. Cope, a partner at the Murdaugh firm, who recounted the story of when he told Mr. Flemming about this fake forge account and about what had transpired at the firm and about the fact that they had caught Mr. Murdaugh stealing money from the firm. And I cited to you, his testimony, and the crux of his testimony was that Mr. Flemming immediately brought up the Satterfield case. He was calling him about a completely different matter. Mr. Flemming's the one who brought up the Satterfield case and said, oh my God, we had the forge account in the Satterfield case and it was for millions. And Mr. Cope's clear impression was that Mr. Flemming was shell-shocked. And I say this, Your Honor, and I give you this information not to minimize or downplay or excuse any conduct of Mr. Flemming, okay? Because what we are here today for is a sentencing. As Your Honor knows, Mr. Flemming has pled guilty to each and every count that he's been charged with. That doesn't happen very often. He pled guilty to all of the conduct in federal court, and he's pled guilty in this court to the conduct. And so he's not here to make excuses for himself or to call himself a victim or to place the blame on anybody's shoulders other than his own. But I have to take issue with the theme of Mr. Waters' closing argument during this process here. He says that Mr. Flemming's guilty plea is the equivalent of pleading guilty to speeding at the rate of 58 miles an hour in a 55-mile zone when he's really going 90. And I have to say, with all due respect, this analogy is a gross mischaracterization of Mr. Flemming's guilty plea and the illegal conduct that he has fully acknowledged. He's pled guilty to each and every count in state and federal court, and that's a total of 24 felony counts. And that's hardly a speeding ticket. And he has not run away from his guilt in this case, not in any way whatsoever. He has, as Mr. Waters would have you believe, he's not run away. He has confronted his actions. He has stepped up to the plate. He has fully acknowledged that he was wrong, that he committed illegal acts, and that he is guilty. And he can only give this court and he can only give the government the facts as he knows them. That's it. He can't make things up about himself or other people. He can't say things that aren't true. He has acknowledged his guilt, though. And as Your Honor's aware, that is not the case in most cases. In most cases, first of all, people aren't always prosecuted in both state and federal court, even when there's concurrent jurisdiction. Many times one prosecuting entity defers to the other. That's generally the normal course of business. Your Honor was a prosecutor. I was a prosecutor. That happens all the time. And that's not the case here, and I'm not here to complain about that. And we're not here to complain, and we're not here to subscribe any kind of motive to those decisions. But what I do know is this. I know that the South Carolina Attorney General's office and the United States Attorney's office share the exact same goals. And the primary goals of those offices are, number one, to protect the public, and number two, to promote respect for the rule of law, and number three, to defer and deter future misconduct, and also, in the end, to ensure that a punishment that is sufficient but not greater than necessary is imposed. And I submit to Your Honor that all of these goals are accomplished in a concurrent sentence. No individual should be forced to serve two separate sentences for the exact same illegal conduct. And I want to address a matter that Mr. Bamberg and Mr. Waters have both raised regarding the Pinckney matter. The Pinckney matter was fully included in the state sentence, and Judge Gergel made that extremely clear. It was included in the loss calculations. They were notified under the Mandatory Victims Act. The loss amounts were included in the loss calculations. The restitution was ordered on the Pinckney case. Ms. Pinckney and Mr. Bamberg were available to speak at the sentencing. They attended all the hearings that I'm aware of, and they've been given treatment just as any other victim in federal court. So that matter has been heard, and it wasn't litigated because Mr. Flemming acknowledged his guilt in those matters. And so this idea that justice hasn't been served in that case, I find, I take issue with that, because it has. I mean, you don't order restitution in a case unless there's findings made and unless they are considered victims in the case, and unless that conduct was folded into the sentence created by Judge Gergel. And so, Your Honor, what I would submit is that the desire to pursue dual prosecutions it's within the discretion of these prosecuting bodies, but it also, that desire still has to be tempered by the rule of law. And justice, I would submit, is not served for South Carolinians or defendants by obtaining multiple convictions in a high-profile case and requiring a man to serve two separate sentences for the same offenses. And that, Your Honor, is consistent with the rule of law. I would submit, Your Honor, that, and there's been a lot of talk about this involves a state license and a state court system and state judges, and I don't disagree with any of that. Of course it does. I mean, that's why we're here, because Mr. Flemming has admitted guilt in that. But when you look to, who the United States Attorney's Office and the Attorney General's Office, who they serve the public. And it's not two separate publics, it is the public. And I don't even say it's to the citizens of South Carolina, because they serve the non-citizens too. They serve everybody. And so I don't understand the division that's being tried to create here with respect to, justice can only be done here in this courtroom. Of course, this courtroom plays an integral role in serving justice. But Your Honor, I believe, understands that the role that these prosecutors have and the role that the other prosecutors have are the same. And they generally work as a team, and they generally work to the same ends, and that is to see justice served. If you look to the American Bar Association's standards on who the client of the prosecutor is, there's a section, and it's in a publication they put out called the Criminal Justice Standards for the Prosecution Function. And it says the client of the prosecutor is the public. And it's not any particular government agency, law enforcement officer, or unit, or witness, or victim. When investigating or prosecuting a criminal matter, the prosecutor does not represent law enforcement personnel who've worked on the matter, and such law enforcement personnel, they're not the prosecutor's clients. The client is the public for both prosecuting entities. So, Your Honor, I would submit that in these proceedings, those purposes are being served. And I don't take any issue with the representation that the Attorney General's office has made, that they have been a central role in this case and that SLED's been a central role. I wouldn't dare to endeavor to do that, Your Honor. Everybody has an important role in this process, and certainly the Attorney General's office and SLED has too. And from my understanding, from all the press releases that have come out from both bodies, they have embraced the idea that this was a joint investigation and there were joint efforts by everybody involved, all the agencies involved, to bring this case to justice. And Your Honor, I would like to take some time to talk about Mr. Flemming and his life before this, his family, his community, many of whom are here today. You've got a packed courtroom. And I would submit, Your Honor, that doesn't happen every day. As Your Honor might be aware, I think that Mr. Flemming is overwhelmed, and he knows how lucky he is and how grateful he is to have the support of so many people. And contrary to what the comment Mr. Waters made, they're not here because they have to be. They're here because they want to be. They're here because, you know, they understand that Mr. Flemming made some terrible decisions. They understand that this has forever changed the course of his life, but they are forgiving and they are supportive. And I think it's a beautiful thing to see, I believe. But Your Honor, I want to take just a brief opportunity to introduce you to Mrs. Flemming. She's here. They've been married for 25 years. She's seated in the courtroom in the front room. His parents are also here. They're Caroline and Frank Koslick and Astor and Catherine Flemming.
Do you want them to stand so I'll know who you're talking about?
Sure. If you all would stand, I would appreciate it.
And who's standing?
So on the far right, we have Eve Flemming. Ms. Flemming's also a member of the bar. She's a public defender here in this area and has worked with juveniles her career. And then we have Mr. Flemming and his wife, Catherine. And then we've got Caroline and Frank Koslick, Mr. Flemming's mom and stepfather. And so, you know, not only have these friends and supporters and this family been here today, they were here. A lot of them came to his guilty plea in Williamsburg County, and a lot of them came to his federal proceedings as well. So it's a very, I can tell you Mr. Flemming is overwhelmed with gratitude for that and doesn't necessarily believe that he's deserving of it, but is extremely grateful. Mr. Flemming also has 2 children. They are not here today. One's in college, and Mr. Flemming felt that it would be better for him to continue his studies and focus on school than he came to the federal plea, and so he's not leaving school to come to this. His daughter just started a job with the Department of Defense.
Do you want them to continue standing?
Oh, no, I'm sorry. I apologize. His daughter's not here today. She's overseas. She's just started a new job, just graduated from college. Mr. Flemming's very proud of her. They all are. She was at his federal plea. And so, you know, I can tell you that the friends and supporters that he have, and we've talked about this in our sentencing memorandum, but I think that it sheds a lot of light on his unique personal history and characteristics, because this is his community and they're here for him. He's had some extraordinary good works. And so I want to take a few moments to talk about that, just to give you some additional insight. And I want to make sure, Your Honor, that I preface these comments by saying nothing that I'm going to say or that his supporters are going to say about him and about why we're here today is meant to diminish his acknowledgement of his guilt or his acknowledgement of the wrongfulness of what he did. Mr. Flemming acknowledges the seriousness of his actions. He feels nothing but remorse, and he has expressed that remorse on multiple occasions, but he specifically did it at the sentencing hearing in federal court, and he's going to do it again today, Your Honor. And you know, I'm sorry that there are some that don't believe it's sincere remorse. I think, you know, Your Honor can be the judge of that. I know that when Judge Gergel listened to his remarks and to the remarks of the people that spoke, he did believe that he was remorseful. And, you know, it's going to be really hard for me to talk about Cory Fleming's life and do a better job of describing him than the people who have written you letters. And I know Your Honor has received a lot of letters. People are still writing me letters. As of yesterday, I was getting new letters. They keep coming in, Your Honor, and I think that's a testament to how strongly people feel about Mr. Flemming. And a lot of these people have a different story about how Mr. Flemming has made an impact on their lives, how he helped them, how he was there for them when they were in need. They're letters that are written by people from all walks of life. Some live in this Beaufort community, and some are from far away. And some are from our older citizens, and some are from very young adults. And some are from his peer group and his former colleagues. And, you know, these people aren't all people that know each other, but they all have stories about Mr. Flemming. And I would submit to you that there are a couple of common themes that run throughout these letters. The first observation that I had when I read these letters was that, you know, it sort of was in keeping with the theory that I've had since I was a judicial law clerk, and that is that you can tell a lot about someone from how they treat the courthouse staff and the non-lawyers in our system. You've received a lot of letters from some of those people, and they talk about the Cory Fleming that they know, and those people include, you know, a bailiff and somebody who worked in the clerk's office, people who have worked at the solicitor's office with him, a retired state trooper and a court security officer who said that there are not enough accolades in the English language to describe his personality and character. You know, there are several letters from people who worked as his paralegal. There's a letter from an agent with the South Carolina Department of Probation and Parole who's known Mr. Flemming for 30 years. And she describes him as, quote, a wonderful human being. She says his character, his work ethic, and behavior over the course of our personal and professional relationship has been above reproach, and his dedication to serving the community and his clients has been inspiring to witness. And, you know, Your Honor, in addition to the courthouse, the letters that I have received from the court personnel, I've also gotten a chance to personally observe people who have interacted with Mr. Flemming when I have gone to court with him. And this is before he was in custody, obviously, and even, you know, after he's been in custody. But there have been just a number of people who've approached me and who've approached him to just say, you know, that they were praying for him and that they were thinking of him and had nothing but good things to say about Mr. Flemming. And so what this tells me about Mr. Flemming is that, you know, for decades, he has treated all of the people who play a unique and important role in our court system with the utmost respect, kindness, and professionalism. And the second theme that I see emerging from these letters is that, you know, I think you can tell a lot about a lawyer from the way he treats young lawyers. And, you know, there are a lot of letters that Your Honor has received from people who knew Mr. Flemming when they were a young lawyer. I remember being a young lawyer. It's scary. You don't know what you're doing. It's intimidating. But many of these people talk a great deal about how Mr. Flemming would step in and help. You know, when they were first starting, he saw them in court. He understood they didn't know how to do something. He gave them guidance. He gave them advice. You know, he helped them through a hearing. He was never too busy to assist and offer advice. They say when they needed something, they could stop by his office. And, you know, he was never too busy. He would take the time to introduce them to people while he was at the courthouse or at a bar function. You know, he made them feel welcome. They also talk about Mr. Flemming's selfless acts of kindness and helping people who were in the courtroom who didn't have a lawyer because they couldn't afford one, and he helped them anyway. And, you know, Mr. Flemming wasn't writing down these hours to try to get pro bono, you know, lawyer hours or become, you know, known as a pro bono lawyer. He's doing it just simply to help people that needed help. Some of the letters talk about the fact that if the bar had a fundraiser, Mr. Flemming was the first to volunteer his time, to help. The letters describe Mr. Flemming as a lawyer who would stay involved in his clients' lives. He'd help them get jobs. He lent them a car, mentored their children. The list goes on. One letter notes that he's represented the families and the victims of violent crimes free of charge many times during his career, and that he would go above and beyond to help these people through that process for no compensation, only because he knew, and having had a wife who was a public defender, he knew, what that's like, what it means to be in that system. And I do want to quote one letter, Your Honor, from one member of the bar. He said, "I do believe at worst Cory is a good and decent man who succumbed to a very unfortunate lapse of judgment for which he has already paid very dearly." So, Your Honor, I would submit to you that all of the good things that Mr. Flemming did for the legal profession in South Carolina over 29 years, you must also take that into account when fashioning your sentence. And I know that, Your Honor has been sentencing people a long time. I know that it's probably a very difficult part of your job. And I know that you take genuine care in doing this. But when you sentence someone as a whole person. And when you look at Mr. Flemming's life outside of the practice of the law, there's another theme that runs through it, and that is service to his community, service to others. Some of these letters talk about Mr. Flemming and his life as a neighbor, his life as a landlord, someone they knew from the YMCA, who he was very active in getting built in this county. His church. And you look at what they say about Mr. Flemming. They say that he's the guy that comes over at the crack of dawn on Christmas morning when your pipes are broken. He's the guy that helps you move in on the day your moving truck pulls in and then brings you dinner. They talk about the guy that helped with home improvement projects and never asked for anything in return. He's the guy that made sure you had a ride home from the hospital after you had a stroke. These are all from the letters, Your Honor. He's the guy who cried with you when he discovered that your mom had Alzheimer's, and then took the time to take your mom to lunch the next day to make sure he was spending some time with her. There's somebody that some of the letters talk about a man that Mr. Flemming discovered was homeless, and how he helped him find a place to live and has helped him get work. The woman who cleaned his house for years talked about how he treated her like family and invited her and her family to share holidays with them. And so, Your Honor, the stories, they go on and on about the help that in the community that Mr. Flemming has served for so many years. One of the things that stands out to me are the single parents that Mr. Flemming has helped. I mean, they talk about the fact that, he did work around their house. He spent time with their children because they didn't have a father. One woman said, who was an 18-year-old single mother when she met the Flemmings, said, "Cory, quote, changed the trajectory of my life, and he changed the trajectory of my 22-year-old daughter's life. He invited her to a play group, befriended her. He drove her daughter to school for 15 years, lent her a car when she needed it, invited them on fun outings, and made them feel like a part of the community." Another person that you're going to hear from today who was not at the federal sentencing, but who has come a long way to be here today, is Miss Blue. She was another single mother who rented a house from the Flemmings, and she's going to talk about how she was treated by Mr. Flemming in particular. The fact that when she needed help, when she couldn't make ends meet, he was there for her and didn't require her to pay rent. When she talked about when her son got in trouble, he was there for her son. So she's here today, and she's going to address the court. Some of the other letters talk about Mr. Flemming being like a parent to many of his children's friends. There's one couple, and their children's friends were in their early 20s, and I thought this letter was so insightful, written by somebody that young. And she said, "I wish that you know that Cory is so much more than this gross era of judgment. Cory is the type of person who treats strangers like friends and friends like family. I have witnessed countless examples of kindness and generosity towards others, organizations, and their families. So what I would submit to Your Honor, unlike the picture that Mr. Waters has painted for you, that Mr. Flemming was using his, his goodness for evil, what these letters reveal and what these people are going to tell you is that over his lifetime, Mr. Flemming has demonstrated the fundamental values that sustain a community. Another constant theme about Mr. Flemming is him as a father, him as a husband and as a son. And in every single one of the letters, because everybody that knows Mr. Flemming knows that his family is the most important thing in his life, his family and his faith. They all describe him as a devoted family person, loving, caring, present, and someone who sets an example for other peoples in the community about his treatment of his family and his parenting skills. And, Your Honor, this is, I think, as Your Honor knows, all of these cases, and in every case, whether it's white collar or whether it's, any kind of criminal case, it's always hard on the family. And, I think that if there's any solace that Mr. Flemming takes in the decision that he's had to make here, which was to own up to his guilt, it is that he's demonstrating for his children what you do when you make a mistake. You step up, you own it, and you admit you were wrong. And that's what he's done. And that's what he hopes his children gets out of this. Because what he has done is try to do everything human possibly to right the wrong here. You've heard from Mr. Bland that he was the first person to step up and return every bit of the legal fee that his firm took in the Satterfield matter. He's been the first person in this matter to plead guilty, period, and to own up to what he's done.
So that his firm took?
I'm sorry, that was issued to his firm. The total fee, $672,000, went to Moskun and Flemming, and then it was split. So yes, that was all returned, Your Honor, in that case. But Mr. Flemming acknowledges his guilt, obviously, in the role he played in getting that fee. But Your Honor, he has stepped up, and this has been obviously a very challenging period in his life. The thing that his friends and his supporters and people know about him, though, is that they believe, and I believe, have faith, that he will learn and he will grow from this experience, and he will come out of this better and stronger. And that's the point of punishment. Part of that is rehabilitation, and I would submit to you, Your Honor, that that's already started occurring. When Mr. Flemming's law license was suspended, he didn't curl up in a ball and lie in bed, okay? He didn't, portray that he was bitter or angry at the world. What he did was started working for Habitat for Humanity. He's very skilled in construction, and he immediately began volunteering his time there because he thought it was the one thing that, he was determined to be productive and determined to be useful in his community and to do something that he could put his skills to work and help other people. And you've got a letter from somebody at Habitat for Humanity who said that Mr. Flemming brought kindness, talent, and humor to the work site. And what I would say about that, Your Honor, is that this speaks volumes about Mr. Flemming, because if you're able to bring kindness and talent and humor to others during the worst period of your life, that's something else. I would just submit to you, Your Honor, that these letters, as a whole, collectively, they're remarkable. And I told Judge Gergel this, and I'll tell you, Mr. Flemming's never read these letters. And I didn't know these stories about Mr. Flemming until I read the letters, because he's never he'd never told me about some of these relationships or some of the people that he'd helped through these things. But he's never read the letters because, it's very difficult for him to think about the fact of how many people he's disappointed in this case. But what we do know, Your Honor, what I know and what his family and friends know is that at the heart of this, he's a good person who made some very bad decisions. And we know that. We know from our experience that good people do make bad decisions. But I would submit to you, Your Honor, that we are all better than the worst thing that we've ever done. And I want to say for a minute, Mr. Bland mentioned the Georgia bar and the very beginning of this process. And what Your Honor is probably aware of, having been a prosecutor, having been in this system for a long time, Mr. Flemming's not unlike 99.9% of the people that I've seen over 30 years in these situations. And he didn't fully come to terms with what he had done immediately. He admitted to some ethical violations, but he did not admit to his criminal conduct initially. But, he made a decision, and it was a decision made this year, to hold himself fully accountable for his actions. And simply because, not because as Mr. Bamberg put, the feds came and knocking. Mr. Flemming's been aware since the very beginning of this that this was a joint federal and state investigation. So the feds have always been involved. There was never any surprise there. But he decided, Your Honor, that he was going to cooperate and he was going to plead guilty. And he wasn't made any promises. He didn't receive any deals. There's no deal. He pled guilty in federal court, and his sentence was calculated by the sentencing guidelines. Like I said, it included both the Satterfield and the Pinckney matters, and Judge Gergel sentenced him pursuant to those guidelines. There was no variance, there was no downward departure, there was no stipulation of a sentence. He took the sentence that was within the guideline range, and he didn't know what that guideline range would be when he pled guilty, and he had no idea what would happen or transpire in state court. But at the end of the day, he made a decision to have faith in this system and to expect, like has been his experience and his wife's experience in the judicial system for a long time, that he would be treated fairly. And that's all he's asked for, Your Honor. That's all he asked for today. I would submit to you that he has accepted responsibility for his conduct. He did not put either the state or the federal government through lengthy litigation or a trial. We didn't come here today to quabble about a trial date. We came here today to fully acknowledge the illegal conduct to which he engaged. I know that I've provided Your Honor with a transcript from his federal plea. I think it's very, very clear in that proceeding, in addition to this proceeding, that he has acknowledged his illegal conduct. And not only that he is deeply remorseful for his actions. And he appreciates the fact that his actions have impacted innocent people. And that's the reason he pled guilty. And I will say he is extraordinarily grateful to the Pinckneys and to the Satterfields for their grace. During the federal sentencing hearing, they said they forgave him. They said that again today. That's hugely meaningful to him. And I don't think they'll ever understand how meaningful that is. So we appreciate that, and we appreciate the gracious manner in which they've handled this. So, Your Honor, I would say that Mr. Flemming has suffered, and he has paid a very, very dear price in this proceeding and in the other federal proceeding that would discourage him from ever engaging in similar conduct. And I strongly believe that Mr. Flemming will serve one day as a very important person who can share his story with other lawyers as a cautionary tale, with just other people. And that in and of itself, Your Honor, will promote deterrence. I believe that the tremendous consequences that he has felt in his professional life, he has voluntarily submitted his resignations to the bar of South Carolina and of Georgia. He will never practice law again. And, you know, that is, it was a profession that, although he made some profound mistakes in, it was a profession for a long time that he loved. And so that itself is a tremendous consequence of his misconduct. Also, Your Honor, I can't not let it be said that the notoriety that has surrounded this case and the publicity that has surrounded it has itself, will serve as a significant general deterrence, but it is not something that every defendant has to deal with. You know, it has been quite, as Your Honor well knows, quite significant. Your Honor, I have some people that would like to address the court, if the court would listen to them, and I would like to call them up now if that is acceptable to Your Honor. And then Mr. Flemming also has some remarks that he would like to make to the court.
All right, we're going to break for lunch now for 1 hour and 15 minutes. It puts us about, what's that, a quarter to, I guess it'll be a quarter to 3. So we'll be in recess, 1 hour and 15 minutes.
Very, 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 very smiling. I love you. Love you and see you here.
What's that? Get our buildings
No, stand up. I knew you'd get it done. Thank
Y'all don't have any more character witness.
I'm going to need it.
You just want to do it over here instead of over there, right? One, two, three, four, five, 6, 7, 8, 9, 10. 1, 2, 1, 2. 1, 2, 3, 4, 5.
I just, well, as long as you're open base with it, I don't have any gaffers to it. You ain't going nowhere now?
Okay.
Yes, thank you so much.
I used to work up there in this courthouse.
Yeah,
But
it's a
thank
great
you,
letter.
great job.
Hey, thank you.
I hope the feds only got it 4 years. They don't like these guys. Huh?
It's all about
Just
cameras.
Yeah.
Camera.
Yeah, you did a marvelous job.
Thank you.
Yeah, for doing it.
Thank you. It's tough. He's somebody I really care about.
Yes. I've known him a long time.
Yeah.
I remember when he first got out of law school, he worked for the solicitor. Cory. And then he worked for Jim Moss. And I worked at the federal courthouse.
All rise, come to order. This court is in session. Thank you. You may be seated.
Ms. Barbier?
Your Honor, may it please the court, your courthouse staff is nice enough to move the microphone to this side of the courtroom. And so I will have the people who would like to address the court come to that microphone if that is acceptable to the court.
Sure.
Okay. The first person that, oh, I'm sorry, Mr. Flemming needs to be brought into the court.
No, we need him.
Thank you, Your Honor. As I was saying, the first speaker that I'd like to call up to the microphone is Mike Miklowski. He's a member of the Beaufort community. And also a member of the bar, Your Honor.
Good afternoon, Judge.
Good afternoon.
My name is Mike McCloskey. I'm privileged to practice law in this community for 57 years. I'm also privileged to call myself a trial lawyer. I've known Cory Fleming since he first started practicing law. However, I've known his family literally since the first day I moved to Beaufort, and that was March the 3rd of 1967. I was at the hearing when Judge Gergel sentenced Cory Fleming. It was a remarkable proceeding. And the thing that made it remarkable was Cory Fleming. I remember Ms. Pinckney telling Cory that she still loved him and that she forgave him. And I never will forget his response. I don't know how many criminal cases I've handled. I don't know how many times I've stood up there and represented people who had either gone to trial and who were waiting sentence. I just don't know. But I've never heard anyone, after being forgiven, respond by thanking her and then following closely thereafter. And I understand you have a transcript of that proceeding, and I invite you to see if I'm correct in my recitation. Immediately thereafter, Cory Fleming said words I've never heard from anyone in his position. I don't deserve to be forgiven. I do not deserve to be forgiven. I've never seen a man empty himself to that extent. He was thoroughly disgusted. He admitted his behavior was a betrayal of trust that was placed in him. He admitted that he had disgraced his family. He admitted that he had dishonored his friends, his profession, his family. That's the Cory I saw a little over a month, no, a little less than a month ago. That proceeding was on the 15th of last month. A little less than last month. Well, why would that be important? I've heard a lot of negative stuff about Cory Fleming. And there's no one here, his family, his friends, anybody that's here to support Cory, that supports his conduct that brought him in front of you today. They didn't support it in front of Judge Gergel on the 15th of August. However, they realize that there is great wisdom in a little piece of scripture found in the 51st Psalm, which is David's great lament after Nathan brought to his attention his great sin. A broken and contrite heart, O Lord, you will not despise. We cannot embrace Cory's conduct, but I'll tell you what all of us do embrace. We embrace Cory in his broken and contrite state. And to what purpose would we do that? Why would we do something like that? Because we see a goodness in Cory that has been covered up, but is coming to fruition now. There's been a lot of discussion about sentencing and the bad acts, rightly so, that Cory has committed. But I'm reminded that human nature and human behavior can change. Well, what is the most powerful vehicle to change human behavior and nature? It's adversity. It's struggle. We don't have our kids grow up healthy by giving them cream and ice cream all the time, cake and ice cream all the time. We subject them to adversity. Now, this adversity is brought on by Cory himself. I wonder how many of us can claim that our conduct has been so pure, so innocent, that we haven't had the chance to grow up through adversity. No, we can't excuse, justify, or defend the events that brings Cory in front of you today. But we're not going to leave him. We're going to actively participate in his restoration in this community, his recovery, his healing. And through that, I hope that the court will find some assurance that through this period of adversity in Cory's life, he will grow, change forever for the better. I thank you for the opportunity of appearing before you in behalf of my friend, Cory Fleming.
Your Honor, next, Shannon Wilkes would like to address the court.
Good afternoon, Judge. I met Cory and Eve in 1998 when I moved to Beaufort. I needed a job, and I was a young paralegal at the time, and I began to work for Cory as his paralegal, and I did so for 2.5 years. Cory was a relatively new attorney, and like I said, I was a new paralegal, but through working together, and Cory still reminds me of this today, we learned a lot from each other. We had a positive and open working relationship where he treated me like a colleague, and not just his paralegal or someone who worked for him. I worked with him. Cory always treated me and his clients with respect, compassion, and kindness. I have witnessed many times firsthand the love and devotion that Cory has for his wife, Eve, his children, his parents, his extended family, and his friends. One evening during a dark and desperate time in my life, and Cory probably doesn't even remember that he did this for me, I knocked on the front door of Cory and Eve's home. When Cory opened that door, he saw me not just as his paralegal, but a friend in need. Neither one hesitated to let me in that door and give me a shoulder to cry on. I'm here today as a supporter of Cory. Being a supporter of Cory does not mean that I don't understand that he made bad choices, because I do understand. And being a supporter of Cory does not make me a victim of anything. I am proud to stand here today, and I'm proud to see that Cory has taken responsibility of his bad choices. And these are choices that he cannot change. But he can choose how to face the effects of the choices he's made now and in the future. And I believe Cory is already doing that by taking responsibility and truly being remorseful, because he is remorseful. He and I have talked on numerous occasions and have discussed our mutual Christian faith. We've shared scripture, we've shared prayer, and lessons learned from this scripture. And I know through this faith, Cory will live a full life, a life full of purpose. And he has a willingness to help others find their own purpose. Thank you, Judge, for letting me speak. And I ask that you take the words that I've said into consideration in Cory's sentencing today.
Your Honor, next we have Rich Schiavella.
Good afternoon, Your Honor. My name is Richard Chiavello. Thank you for the opportunity to give me this chance to speak on behalf of my friend Cory Fleming. I met Cory 22 years ago when we both became new parents. A couple years later, we both welcomed our second child, our children. Over the years, my family and I became very close friends with Cory, his parents, his wife, his children. We spent many holidays, birthdays, and weekends together. He's the last person that I ever thought I'd be standing here talking to you about today. I've only known Cory to be a loving son, husband, father, and friend. I believe Cory to be a good man who made a bad choice. I also believe that when he returns to his family and friends, he will dedicate his life to earn the respect, trust, and admiration of all who come to know him. Your Honor, I ask that you show Cory as much leniency and mercy as the court will allow. Thank you.
Your Honor, there are several people that were here earlier who had to go. They didn't know it was going to last this long and had commitments, a very critical doctor appointment, and they left me their statements, and I'd like to read them if I could.
Are they the same ones that you emailed to me or had me to read before?
There are, Your Honor, there's one statement from a person who's also written a letter, Kevin Green, and he says much of the same things. So if Your Honor wants to simply rely on the letter.
You know, you submitted them all to me to read, and I've read them, and so I don't need you to read them again if you've already done that.
It's not the same letter.
Oh, another from the same person?
It's the same person.
Okay.
Okay. And, but I just wanted the court to know that there were a few other people. In addition, Your Honor, I have Ms. Denise Davis.
Your Honor, I'm grateful for the opportunity to speak on behalf of my friend Cory Fleming. I've had the privilege of knowing Cory since 2009, and I'm eager to share my insights about his character and the positive impact he has had with my family and our community. I first met Cory at the YMCA, where our shared passion for competitive running and physical fitness brought us together. Over the years, we participated in numerous local running events, forging a strong bond based on our shared interests and values. I've had the opportunity to witness firsthand Cory's dedication to the YMCA. For the past 8 years, I have overseen the YMCA's River Swim, a signature fundraiser for our Learn to Swim program. Cory, alongside his daughter, participated in the challenging 3.2-mile swim. And when I approached him for sponsorship and support of the worthy cause, he didn't hesitate. In addition to our YMCA swim, I could always count on Cory to sponsor and actively participate in a running event I chaired for the Parents Association of my son's school. He generously extended beyond financial contributions. He consistently went out of his way to help others. I can personally attest to this. I'm a single mother to 3 sons. There have been times, excuse me, when I relied on Cory's expertise to fix various household issues. He never hesitated to lend a hand. One vivid example is when my outdoor shower pipe froze and started spraying water everywhere on Christmas morning. Despite the holiday festivities, Cory was there to help at a moment's notice and without hesitation. Moreover, Cory's unwavering commitment to his family is truly commendable. I've had the privilege of not only being friends with Cory, but also developing a close bond with his family. During my own challenging times, Cory and his family extended their kindness to me without hesitation. Their support and empathy served as a beacon of light through my moments of difficulty. Cory has been a guiding figure in the lives of my sons. He's been a mentor, providing them with support, advice, and empathetic ear when they needed someone to confide in. His genuine care and interest in their well-being have made him a beloved figure in our home, and we often refer to him as Uncle Cory, despite not being related by blood. Cory's character is one of generosity, acts of kindness, and a strong sense of responsibility towards his family, friends, and community. He has consistently demonstrated his commitment to making a positive impact, and his contributions have left a lasting mark on the lives of many, especially my family. I respectfully request that you consider my testimony when determining Cory's sentence. I firmly believe that his actions and genuine goodwill he has shown throughout the years are a testament to his character. I kindly ask you for your leniency, mercy, and grace in this matter. I believe Cory's positive qualities should be weighed during the sentencing process. Thank you, Judge Newman, for allowing me to speak on behalf of my friends.
Next, Your Honor, is Lisa O'Brien.
Good afternoon, Judge. I am Lisa O'Brien, and I'm a Beaufort resident, born and raised here. I met Cory and his wife and children at the Y. I taught spin there for about 16 years, and he and his family actively participated in my classes. In 2011, our oldest son was brutally attacked and beaten and robbed in his home in the middle of the night here in Port Royal. I didn't ask for help, but Cory knew my anguish. He saw it on my face, and he approached me outside after class and told me that he and his wife would do anything to help us through this process. Even though the prosecutor would take control, he would be there for us. He spent countless hours talking to us over the phone and in person and just helping us to understand what we were going to face. I've stood in one of these courtrooms at least 5 times as the mother of a victim. Each time, Cory has put himself out to be there for our family without anything asked or without any bragging or patting himself on the back for being a good person. In one of my conversations with Cory at the Y, he told me that one of the hardest things he had to do was to stand in the courtroom while people that didn't have an attorney didn't know what to say, when he could easily go up there and help them. And every day it was hard for him. And there's one more thing I want to mention. When all of this happened, we moved upstate a couple of years ago. And when all of this happened, I came down and I wanted to go into one of the classes and see my old friends. And I asked Cory if he was going to be there, and he showed up. And I told him, I said, you know, I'm not going to ask you anything about these things. I don't want you to feel pressured to ever be around us. And he stopped me in my tracks, and he said, no. I have learned from this already things about myself I didn't even realize I needed to know. The remorse was clear, and his actions to stop me and tell me that he had guilt are something I can't even explain. I didn't ask him, and he just told me. I think what I want to say most is I'm here on my own accord. I drove 3.5 hours to come. I don't feel obligated. I don't feel like I have to be here, and certainly I'm not forced to be here. I would stand up for Cory in a minute, and Eve and his family, because one thing in somebody's life that happens a couple of times does not define them. He is more, the whole picture of who he is more than this. And this is terrible, but this does not define him. And I just ask for you to consider that.
Was the assailant apprehended?
There were 5 assailants, and they were apprehended the night of the crime. Mm-hmm. They were caught by Detective Rue, and it took about 2 years to prosecute. They did all plead guilty.
How much time, what was their sentence?
It ranged from 15 years to 20 years for all 5.
15 years to 20 years each?
Yes, sir. Well, each person was sentenced with a concurrent. So they were charged with 3 things: burglary in the first degree, armed robbery, and possession of a weapon during a violent crime. The burglary first degree was 20 years for one individual, and the armed robbery 20, and 5 for the weapon. And that process matched each person down the line.
How old were they?
They ranged in ages from 23 was the oldest person. The youngest one was about a month from turning 17.
And what year was that?
2011.
Are they still in prison?
Yes, sir. The first one will be released next year.
All right. Thank you.
You're welcome.
Your Honor, next we have Laura Blue.
Good afternoon, Your Honor. My name is Laura Blue. From 13 years being in the Beaufort area, a citizen of Beaufort, South Carolina. I've known Cory as being my landlord. It's just so much I could say about this man. I have 2 children. We were homeless, living in a hotel. It was during Christmas time. We were transitioning from the hotel to the residence in which he was allowing me to rent. And when I went into the home, so much I can say about this man. He immediately shared with me that I didn't have to do the first month rent and make sure I get my kids some toys for Christmas. My son was 7, my daughter was 9. We've been in the home 13 years. My son graduated from Beaufort High School. He's now in the United States Navy. I have a 22-year-old daughter. She's currently the business manager at St. Helena in Port Royal. I have a 4-year-old grandchild that actually came into the home while we were there. I would say from landlord to family, that's how we look at him. Both of my children looks at him very highly as an uncle. He's very respected by both of them. In spite of what's going on, we talked. I've relocated to Missouri, so I flew in to speak on who he is to us as a family. My daughter spoke at the federal, and I will say this, Judge. During this time, while I was in Missouri, Cory and I talk, try to encourage him, plenty nights through texting and sending scriptures to let him know that in the Bible, God forgive us of all our sins. He asked me when I came down and visit my family here, if it was possible to just come by his home. He needed to share something with me. In spite of the media, in spite of people around me, he called me, him and his wife, went to the home. He talked with me, he shared things. He didn't go in depth or anything. He just let me know. He did something, he was very sorry about it. He just couldn't get over the hump of understanding that he has to forgive himself. I will tell you today, Judge, on behalf of my family, we truly, by no means, look at him more than just my landlord. Again, he's my family. I rest assured his family has supported me tremendously. They didn't ask me to come, they didn't beg me to. I asked them, can I please come? Can I please, every day, what can we do? Because again, like I say, this man took my family in, put a roof over my head with 2 children. And he made sure not one day, if I was late, he overcharged me. Not one day he made an eviction notice or anything. And I've been late many of times. Yet he let us stay in the home. He was ready to renovate the home right before my son was graduating. And I was working for Department of Social Service inside Child Protective Service as an investigator, not making much money. And I told him, I said, Mr. Flemming, if we leave, where could we possibly go for the next 3 months until my son graduated? He said, you know what, you guys stay here, and when he graduates, then we'll go ahead and start the renovation of the home. So I just ask that you just take into consideration what I said about this man. Thank you, Your Honor.
Your Honor, I'm not going to read the statements because you do have letters from Kevin Green, Jay Taylor, and Tom Miller, all who were here earlier but had to go, as I said. But at this time, I'd like my client to address the court.
Okay.
And obviously,
Yes, sir.
Your Honor, excuse me. Thank you for the opportunity to address this court. For many years, I stood in this very courtroom representing people. Many of those people had broken the law. I was very aware that one bad decision or a series of bad decisions can have life-changing and irreversible consequences. Despite knowing this firsthand, I made some terrible decisions and I broke the law. Today, I offer this court no excuses. There are no excuses. I place the blame for my actions on my shoulders, nobody else's. I never imagined standing here and being in this circumstance. I have a profound and deep disappointment in myself. It is a very difficult and constant feeling that I will carry with me for the rest of my life. Today, I'm grateful for the ability to thank the Satterfields and the Pinckneys for expressing their forgiveness to me when I was sentenced in federal court, and for letting me know that they're praying for me. It means the world to me, and it's helping me through a very difficult time. Although I've already made these remarks in federal court, I want this court to know my regrets, my failings, and my heart. And I don't think I can say how sorry I am too much to any of these people. So I'll say these words again to the Satterfield family. Your mother was a very good woman. In the aftermath of losing her so tragically and suddenly, you deserved a lawyer that had only your best interest at heart. You deserve someone to be honest with you. You deserve someone who talked with you. You deserve someone who dealt with you fairly. And you deserve someone who would not betray your trust. I did not do those things. I failed you. To Michelle Pinckney, I not only betrayed you as a client, I betrayed you as a friend. You suffered a tremendous loss that no parent should ever endure. You and your entire family were good to me. I have no words for how empty I feel when I think of how you must feel about me. You deserved much better. I failed you and I failed your family. To both the Satterfields and the Pinckneys, for these failures, I am immensely sorry. I know that an apology is inadequate, but please know that I am genuinely incredibly sorry for my treatment of you. Next, I want to apologize to my former colleagues in the South Carolina Bar, the South Carolina Supreme Court, and the Office of Disciplinary Counsel. My actions have cast a negative perception on the legal profession. I understand that the public's confidence in our judicial system has eroded as a result of this case. I am deeply sorry that my actions have negatively impacted a profession that I loved and people that I care deeply for. I have permanently resigned from the South Carolina Bar because I no longer deserve the privilege of practicing amongst you. I want to apologize to my former law partners and staff. I know that my actions have caused a tremendous amount of stress, burden, and heartache on each one of you. I'm truly sorry for the pain I've caused. I'm sorry to my friends and members of the Beaufort community that I have let down. I love Beaufort. I've always considered myself lucky to live amongst this community. And I'm extremely grateful for those who've stood up for me and offered kind words that were very much needed. my wife, my children, and my parents. I will spend the rest of my life regretting the shame and the turmoil that I have inflicted on our family. Each of you have been a tremendous source of support to me during the past 2 years. I don't feel that I deserve it, but I promise you that I will strive every day to earn back your respect and be worthy of your love. Thank you for standing by me during this very dark time. I love you so much. Your Honor, I know that I deserve to be punished for my conduct. I take full responsibility for my actions. I can assure this court that I will live the rest of my days trying to follow the lessons I've learned, to remember what is actually important in life, time spent with my family and my friends. To know that doing things for others is how to gain fulfillment out of life. It does not come through material possessions. A lot of people have spoken to me, my friends in the community, about what I've lost in this ordeal, but I'm looking at all that I've gained. I've had to take a very hard look in the mirror. I didn't like everything that I saw. I have grown from this both spiritually and emotionally. I have taken stock in my life and realized how lucky I am. I'm incredibly grateful for my wife, my children, my family, and my friends for their support and love. I believe there were times in my life when I took these people for granted, but I'm looking at life through a new lens. When I decided to plead guilty in federal court, I didn't have any assurances of what my sentence would be there or here. But I made a conscious decision to have trust in the legal system, one that I betrayed. I betrayed this system, and I am perhaps undeserving of that. I understand how difficult your role in this process is, and I sincerely thank you for the opportunity to address your court and for considering the information presented on my behalf.
Your Honor, in conclusion, I just make a very, very brief remarks. I appreciate all the courts, the time that you spent with us today, the allowing us to speak and allowing the people that wanted to come and talk on Cory's behalf to be heard. As I said, I know Your Honor has a very difficult job in this process, and I have always observed firsthand the dignity that you treat defendants with. I would respectfully submit to you, Your Honor, that in this case, a concurrent 46-month sentence is sufficient punishment and will protect the public. It will serve as a deterrent. I believe there's already been a significant deterrent effect, but I think the sentence here will serve that purpose as well. Mr. Flemming has accepted responsibility for his bad decisions and his illegal conduct. In the process of calculating his federal sentence, there's an enhancement calculated in to Mr. Flemming's sentencing guidelines, and he was sentenced. So that's what he did. He abused his position of trust and abused his law license, and he's taken full accountability for that. You have heard about his worst days, and I hope you will also know that those bad decisions do not define his life. One of the things the court always considers in these matters is whether or not somebody has a criminal history. Mr. Flemming had no criminal history prior to this case. He has made, I would submit, significant efforts already at rehabilitation, and he's going to continue to do that as he serves his sentences. He has expressed extreme remorse. He only seeks a chance, Your Honor, to serve his time and then rebuild his life. and to be able to be released from prison and still have time to contribute to society. Your Honor, in conclusion, I would submit that a 46-month concurrent sentence will encompass all of the illegal conduct to which he has acknowledged, including the Pinckney case, which I discussed was already considered. The Pinckneys were victims in the federal case. Their loss amount was calculated, their restitution was ordered, and they were treated under the Mandatory Victims Act. But a 46-month concurrent sentence will reflect the seriousness of this offense. It will promote respect for the law, and it will provide just punishment. And I thank you again, Your Honor, for all of your consideration and for you taking the time to hear us today. Thank you.
Thank you, Your Honor. I know this has been a long proceeding, and I'm not going to talk for a long time. Abuse of a position of trust. Your Honor was asking one of the people that spoke on behalf of Mr. Flemming about those terrible crimes that happened to that person and the ages of those people. And we don't know now what their lives were like, their backgrounds were like, the opportunities they had, the privileges they had. And there was very significant accountability for that, for those young men, and rightfully so. But there has to be significant accountability here too. One thing you didn't hear a lot about, Your Honor, was the facts of what Mr. Flemming, even to this point, actually claimed. What we know is that when he first got called by Lee Cope, he said, oh, the Satterfields, but he didn't disclose, oh, I was colluding with Alec, oh, I'd stolen checks, oh, I'd been stealing from Miss Pinckney prior to that. He didn't disclose any of that. In fact, for the longest time, he claimed he was a victim. And then when the state grand jury called him red-handed, he then changed and started to say, out of the generosity of who I am, I cut my fee in half. And so if I did steal, they still were better off than they would have been if I'd taken my full fee. Ms. Barbier read from our memo, and she left out one clause about what the state's position is. And that clause is that what Flemming didn't realize, because he knew that the scheme as usual depended on some significant portion of the funds going to the family so that that sleight of hand works. They're too focused on this right here to know that this is going on behind them. And what Mr. Flemming, when finally pushed against the wall, his final version that went to federal court with, essentially this, Your Honor, that every single one of those forged checks that he cut from his trust account, the $403,000 one, the $2.9 million one, and the $118,000 one, that he believed that Alec, that those boys, that the Satterfield family was going to get every dime of that. And the only thing he was willing to concede once he had finally been pushed against the wall, time after time and revelation after revelation, was that he had withheld that $105,000 in fake prosecution expenses for Alec. And the interesting thing about that is that for you to accept that to be true, what his version is that Alec never even came and got that. Because as we know, there was $113,000 still in his trust account when everything came to light. So what he is trying to admit is that yes, I colluded with Alex Murdaugh, but I didn't think that he had gotten one thin dime of that money. And when the state And she made some discussions about one agency deferring to another, and she mentioned press releases. And of course, as always, when the state grand jury first indicted Mr. Murdaugh and others, that's going back in November of 2021. You know, in a press release, we're going to thank supporting agencies, but she's had those transcripts. She's read the extensive testimony that we presented from the witnesses in the state grand jury in November of 21, and December of 21, and January of 22, and February of 22, and March of 22, April of 22, and on and on. She's read the information about her client that was gathered by state grand jury subpoenas during that time. And when Mr. Flemming sat down and told that story, that I believed that every dime was going to those Satterfield family, that when I was at my dirtiest, my motives were the most pure. That because I had cut my fee in half, even if I'd stolen money, they were still going to be better off than they would have been. And the state said, that makes no sense. And it makes no sense for all that I've detailed for you here today. That course of conduct that shows that he knew what was going on, he was instrumental in it. And so when he talks about accepting responsibility, he's not accepting true responsibility. And that is why there needs to be accountability in state court. That is why that when the state said, hold on, Mr. Flemming, that doesn't fit with the facts, that doesn't fit with common sense, that doesn't fit with all we know about how this went down. Mr. Flemming, and we said, give us some more information, give us some more time. Mr. Flemming instead went down the street and made a deal to just bypass accountability in this courtroom, which this is where the affront occurred. Ms. Barbier went in great detail, and Mr. Flemming said it too, about how he pled guilty in federal court with no deals. No deals. And he talks about how the Pinckneys were considered in the pre-sentencing report, which of course the state doesn't have. We don't know what was in that. But what he leaves out, when they make this great presentation to you, how they pled with no deals, and therefore that's enough. Just let the feds handle it. We just thumbed our nose at the state, thumbed our nose at our obligations in the agreement we signed, and went down the street. What he leaves out is that he was allowed to plead to a single lesser offense, one charge, 0 to 5 years. If you had done one charge of what it should have been, that's a 20-year offense. And even Judge Gergel in the plea transcript on page 75, when they were trying to say, well, there's no deals, we didn't do a substantial or a downward departure, says, well, in some ways, you've already given him a 5K, which is a downward departure motion, by allowing him to plead to the less serious offense. One charge for 0 to 5 years is not enough, Your Honor. It's not enough for the reasons that I expressed to you. It's not enough because of the difference between what was admitted to in federal court and what we have exposed here today. It's not enough because of the difference that today is where there's the first real accountability, a real conviction for Pamela Pinckney. And it's not enough because the state judicial system needs its say for those who abuse it. I said before, a lawyer should not have a decade of conduct and get one-stop shot. For that reason, we submit there should be a lead sentence for the Satterfields and a consecutive lead sentence for the Pinckneys. Thank you, Your Honor.
Thank you. Well, I guess we've been here listening to argument and presentations concerning this, goodness, about 4 hours or more. And prior to that time, I was submitted voluminous materials to review. The one thing that I did not review is Judge Gergel's transcript. As much as I admire him and his capabilities as a federal judge and the great work that he does. I don't defer to the federal court system in making my decisions. I practiced law for 24 years and have been a judge for 23 years. During my time as a prosecutor, I've prosecuted police chiefs, probation officers, professors, and as a judge, I've sentenced church secretaries, preachers, professors, law enforcement folks. But until I came down to this 14th Circuit in March, I never sentenced a lawyer. And that lawyer was sentenced to consecutive life sentences. Now I have a lawyer, co-defendant, colleague of his, facing 195 years in prison. In addition to dealing with and sentencing all those folks, I've certainly dealt with my share of grand larceny cases, people who might steal an automobile, facing 10 years in prison, a shoplifter who, after the third offense, they're facing 10 years in prison. And I've had my share of sentencing people like the assailants who were convicted of the crimes that was mentioned, and dished out a lot of time to many of them. So this is my second time in these 47 years having to deal with an issue of sentencing a lawyer. And I cannot imagine a more devastating, anything more precedent. This is unprecedented. This is unimaginable. This is, I think, the greatest crime for a lawyer in the history of the state of South Carolina. Certainly in the number of years being faced and the impact of the crimes on the citizens of the state. I cannot imagine anyone going to a lawyer in South Carolina at this moment in time and having complete trust in what that lawyer says to them. And of course, part of my years of practice, I've had clients come to me with, and they come and said that they didn't know how much money they got on their case, that they went to the lawyer's office and the check was turned over and they just was asked to sign the check. So they came to me to find out how much money they got in their case. But this is totally unprecedented. I cannot, there's no way. There was a case in this state where the amount of thievery exceeded what's occurred in this case. Now the presentations on behalf of Mr. Flemming were certainly inspiring. Reminded me of the revival that we had at our church last week. Reminded me of funeral services that I've had to attend, particularly within the last year. And I've heard a lot of testimonies, so much so that they can go on and on in churches, you know, at a funeral. And so we ask people to limit their comments to 2 minutes because everyone has so many good things to say. And most folks reminded me of what was said in federal court, sort of a disregard to the dual sovereignty of the state court. You know, I didn't read Judge Gergel's transcript. He's in a different system, a different sovereignty. I've never deferred to a federal court to guide my sentence as a state court judge. Now, for all of the great things that was said about Mr. Flemming, and I made the funeral reference because it's as if he's no longer with us, as if, you know, we're at a funeral, and that he will not have an opportunity to redeem himself. He will not have an opportunity to do good deeds. And someone mentioned that the things that he was able to share his tale with others, well, he'll have an opportunity to share his tale and his story and the consequences of his choices with people that he will meet that will be in dire need of his counsel and advice. Now, since coming here for Murdaugh and doing that trial in March, and I was back here 2 weeks ago for a trial, another trial in Colleton County. A mother who had been Teacher of the Year in the school system there left her 13-year-old totally handicapped and disabled child in a car beginning at 11 a.m. when it was 91 degrees outside, and left that child in the car until about 5 or 6 p.m. And she's constantly in and around the car with her boyfriend. And a climatologist testified that the temperature in that car got up to 139 degrees. And you're talking about remorse, and the testimonies and presentations over this mother and her mistake. She was on methamphetamine with her boyfriend. As remorseful, I cannot imagine anyone giving me a presentation of a mother who loved her child and who went wayward and more concerned about using drugs and pleasing her boyfriend than caring for her child. And she got 37 years in prison, convicted of murder. That was 2 weeks ago, here in the same 14th Circuit. And the folks who came to talk with him and said, you know, she loved her child. Nothing she wouldn't do for her child. She had her child in the Special Olympics. But she abandoned the child. And so when I'm listening to Mr. Bamberg talk about Mr. Pinckney, Hakeem Pinckney, I'm thinking of that same type of vulnerability that child had. He was a child at the time, wasn't he?
He was a late teen, I believe, Your Honor.
Yeah. And so he placed his trust in a respected member of the bar, a very respected member of this community. And I could tell that by all of the folks here. you know, I sometimes say that there isn't very much between any of us. We all have good and we all have bad, and certainly everyone was here to tell me about all the good in Mr. Flemming, but we're dealing with the consequences of the bad, and that is as bad as it gets in this case for a lawyer who has a prior record. He has no prior convictions, but when you carry on a scheme of over a decade, that's a record. Record that did not result in charges or convictions, but a record of his life. And as bad as it was with Mr. Pinckney, then we moved to the Satterfields. Again, vulnerable people. So I imagine, and I know that many of the friends and family and colleagues were totally shocked, not at what the good Cory Fleming has done over a period of time, but this Cory Fleming in these cases. And quite frankly, when the people come to me and wanted to lay the burden on me, said, "Judge, please be lenient," that's not my responsibility. You know, I believe in justice and mercy, but leniency is not part of Micah, the scripture. Facing 195 years in prison. Anything else before I impose my sentence?
None from the state, Your Honor.
All right, Mr. Flemming, if you'll come around for sentencing. My heart bleeds for you because I have no doubt of the quality of human being that you are, as reflected by all of the positive comments. But you must suffer the consequences of your actions in these cases that you're standing before me for. And tempering justice with mercy. It's my responsibility to impose a sentence. And there are so many. If I were to spend time here now imposing a sentence on each of these indictments individually, we'd be here for a few hours probably. So suffice it to say, with regard to the Satterfields, and need my clerk here will take notes for me. On count 10, where the exposure is 0 to 5, the sentence is 5 years. I wrote insurance. Is that insurance fraud?
Yes, sir.
That is count number or indictment number.
That was count 11, Your Honor.
Count 11. On the exposure is 0 to 10. The sentence is 10 years. On the breach of trust with the 10-year possibility or exposure, the sentence is 10 years. On the money laundering, where the exposure is 0 to 20 years, the sentence is 10 years. On the 5-year breach of trust, the sentence is 5 years. On the 5-year money laundering, I believe it is 5 years. And on the computer crime, the sentence is 5 years. And each of those will run concurrent with each other. As to the breach of trust involving the Pinckneys, counts 5 and 9, is it?
Yes, sir.
Where the exposure is 5 years, the sentence is 5 years. The 30-day breach of trust, count 6, the sentence is time served. On the conspiracy charge, sentence is 5 years. On the breach of trust, where the exposure is 10 years, the sentence is 10 years. And that sentence will run consecutive to the sentence that you're currently serving. All the sentences otherwise will run concurrent with each other. I'm going to defer any restitution hearings. I believe it's just too convoluted for me to get a true handle on what the state is seeking and what should be ordered, and I tend to think that it's, well, I don't want to prejudge whether it's necessary or not, but I'm going to defer any ruling regarding any restitution. I'm not sure whether the state is actually seeking it, whether there's an actual loss. If there is, whether the parties can agree. We can have a separate hearing solely dealing with restitution if necessary. As sentence of the court, I give you best wishes, Mr. Flemming.
Thank you, sir.
Thank you.
So I need to take time to work with all this. Unless, were you following everything? You want to put the years on them? Yeah. Anything further here today, Mr. Waters?
No, sir. That would conclude the state grand jury matters for today, Your Honor.
All right, court will be adjourned.
Your Honor, as I was saying, the first speaker that I'd like to call up to the microphone is Mike Kuklowski. He's a member of the Beaufort community.
I'm also privileged to call myself a trial lawyer. I've known Cory Fleming since he first started practicing law. However, I've known his family literally since the first day I moved to Beaufort, and that was March the 3rd of 1967. I was at the hearing when Judge Gergel sentenced Cory Fleming. It was a remarkable proceeding. And the thing that she still loved him and that she forgave him. And I never will forget his response. I don't know how many criminal cases I've handled. I don't know how many times I've stood up there and represented people who had either gone to trial and who were waiting sentence. I just don't know. But I've never heard anyone, after being forgiven, respond by thanking her and then following closely thereafter. And I understand you have a transcript of that proceeding, and I invite you to see if I'm correct in my recitation. A little over a month, no, a little less than a month ago. That proceeding was on the 15th of last month. A little less than last month. Well, why would that be important? I've heard a lot of negative stuff about Cory Fleming, and there's no one here, his family, his friends, anybody that's here to support Cory, that supports his conduct that brought him in front of you today. They didn't support it in front of Judge Gergel on the 15th of August. However, they realize that there is great wisdom in a little piece of scripture found in the 51st Psalm, which is David's great lament after Nathan brought to his attention his great sin. A broken and contrite heart, O Lord, you will not despise. We cannot embrace Cory's conduct, but I'll tell you what all of us do embrace. We embrace Cory in his broken and contrite state. And to what purpose would we do that? Why would we do something like that? Because we see a goodness in Cory that has been covered up, but is coming to fruition now. There's been a lot of discussion about sentencing and the bad acts, rightly so, that Cory has committed. But I'm reminded that human nature and human behavior can change. Well, what is the most powerful vehicle to change human behavior and nature? It's adversity. It's struggle. We don't have our kids grow up healthy by giving them cream and ice cream all the time, cake and ice cream all the time. We subject them to adversity. Now, this adversity is brought on by Cory himself. I wonder how many of us can claim that our conduct has been so pure, so innocent, that we haven't had the chance to grow up through adversity. No, we can't excuse, justify, or defend the events that brings Cory in front of you today. But we're not going to leave him. We're going to actively participate in his restoration in this community, his recovery, his healing. And through that, I hope that the court will find some assurance that through this period of adversity in Cory's life, he will grow, change forever for the better. I thank you for the opportunity of appearing before you in behalf of my friend, Cory Fleming.
Sir, thank you.
Your Honor, next, Shannon Wilkes would like to address the court.
Good afternoon, Judge. I met Cory and Eve in 1998 when I moved to Beaufort. I needed a job, and I was a young paralegal at the time, and I began to work for Cory as his paralegal, and I did so for 2.5 years. Cory was a relatively new attorney, and like I said, I was a new paralegal, but through working together, and Cory still reminds me of this today, we learned a lot from each other. We had a positive and open working relationship where he treated me like a colleague and not just his paralegal or someone who worked for him. I worked with him. Cory always treated me and his clients with respect, compassion, and kindness. I have witnessed many times firsthand the love and devotion that Cory has for his wife, Eve, his children, his parents, his extended family, and his friends. One evening during a dark and desperate time in my life, and Cory probably doesn't even remember that he did this for me, I knocked on the front door of Cory and Eve's home. When Cory opened that door, he saw me not just as his paralegal, but a friend in need. Neither one hesitated to let me in that door and give me a shoulder to cry on. I'm here today as a supporter of Cory. Being a supporter of Cory does not mean that I don't understand that he made bad choices, because I do understand. And being a supporter of Cory does not make me a victim of anything. I am proud to stand here today, and I'm proud to see that Cory has taken responsibility of his bad choices. And these are choices that he cannot change. But he can choose how to face the effects of the choices he's made now and in the future. And I believe Cory is already doing that by taking responsibility and truly being remorseful, because he is remorseful. He and I have talked on numerous occasions and have discussed our mutual Christian faith. We've shared scripture, we've shared prayer, and lessons learned from this scripture. And I know through this faith, Cory will live a full life, a life full of purpose. And he has a willingness to help others find their own purpose. Thank you, Judge, for letting me speak. And I ask that you take the words that I've said into consideration in Cory's sentencing today.
Your Honor, next we have Rich Schiavella.
Good afternoon, Your Honor. My name is Richard Chiavello. Thank you for the opportunity to give me this chance to speak on behalf of my friend Cory Fleming. I met Cory 22 years ago when we both became new parents. Many holidays, birthdays, and weekends together. He's the last person that I ever thought I'd be standing here talking to you about today. I've only known Cory to be a loving son, husband, father, and friend. I believe Cory to be a good man who made a bad choice. I also believe that when he returns to his family and friends, he will dedicate his life to earn the respect, trust, and admiration of all who come to know him. Your Honor, I ask that you show Cory as much leniency and mercy as the court will allow. Thank you.
Your Honor, there are several people that were here earlier, who had to go. They didn't know it was going to last this long and had commitments, a very critical doctor appointment, and they left me their statements, and I'd like to read them if I could.
Are they the same ones that you emailed to me or had me to read before?
There are, Your Honor, there's one statement from a person who's also written a letter, Kevin Green, and he says much of the same things. So if Your Honor wants to simply rely on the letter.
No, you submitted them all to me to read, and I've read them, and so I don't need you to read them again if you've already done that.
It's not the same letter.
Oh, another from the same person?
It's the same person.
Okay.
Okay. And, but I just wanted the court to know that.
I've had the privilege of knowing Cory since 2009, and I'm eager to share my insights about his character and the positive impact he has had with my family and our community. I first met Cory at the YMCA, where our shared passion for competitive running and physical fitness brought us together. Over the years, we participated in numerous local running events, forging a strong bond based on our shared interests and values. I've had the opportunity to witness firsthand Cory's dedication to the YMCA. For the past 8 years, I have overseen the YMCA's River Swim, a signature fundraiser for our Learn to Swim program. Cory, alongside his daughter, participated in the challenging 3.2-mile swim, and when I approached him for sponsorship and support of the worthy cause, he didn't hesitate. In addition to our YMCA swim, I could always count on Cory to sponsor and actively participate in a running event I chaired for the Parents Association of my son's school. He generously extended beyond financial contributions. He consistently went out of his way to help others. I can personally attest to this. I'm a single mother to 3 sons. There have been times, excuse me, when I relied on Cory's expertise to fix various household issues. He never hesitated to lend a hand. One vivid example is when my outdoor shower pipe froze and started spraying water everywhere on Christmas morning. Despite the holiday festivities, Cory was there to help at a moment's notice and without hesitation. Moreover, Cory's unwavering commitment to his family is truly commendable. I've had the privilege of not only being friends with Cory, but also developing a close bond with his family. During my own challenging times, Cory and his family extended their kindness to me without hesitation. Their support and empathy served as a beacon of light through my moments of difficulty. Cory has been a guiding figure in the lives of my sons. He's been a mentor, providing them with support, advice, and empathetic ear when they needed someone to confide in. His genuine care and interest in their well-being have made him a beloved figure in our home, and we often refer to him as Uncle Cory, despite not being related by blood. Cory's character is one of generosity, acts of kindness, and a strong sense of responsibility towards his family, friends, and community. He has consistently demonstrated his commitment to making a positive impact, and his contributions have left a lasting mark on the lives of many, especially my family. I respectfully request that you consider my testimony when determining Cory's sentence. I firmly believe that his actions and genuine goodwill he has shown throughout the years are a testament to his character. I kindly ask you for your leniency, mercy, and grace in this matter. I believe Cory's positive qualities should be weighed during the sentencing process. Thank you, Judge Newman, for allowing me to speak on behalf of my friends.
Next, Your Honor, is Lisa O'Brien.
Good afternoon, Judge. I am Lisa O'Brien, and I'm a Beaufort resident, born and raised here. I met Cory and his wife and children at the Y I taught spin there for about 16 years, and he and his family actively participated in my classes. In 2011, our oldest son was brutally attacked and beaten and robbed in his home in the middle of the night here in Port Royal. I didn't ask for help, but Cory knew my anguish. He saw it on my face, and he approached me outside after class and told me that he and his wife would do anything to help us through this process. Even though the prosecutor would take control, he would be there for us. He spent countless hours talking to us over the phone and in person and just helping us to understand what we were going to face. I've stood in one of these courtrooms at least 5 times as the mother of a victim. Each time, Cory has put himself out to be there for our family without anything asked or without any bragging or patting himself on the back for being a good person. In one of my conversations with Cory at the Y, he told me that one of the hardest things he had to do was to stand in the courtroom while people that didn't have an attorney didn't know what to say, when he could easily go up there and help them. And every day it was hard for him. And there's one more thing I want to mention. When all of this happened, we moved upstate a couple of years ago. And when all of this happened, I came down and I wanted to go into one of the classes and see my old friends. And I asked Cory if he was going to be there, and he showed up. And I told him, I said, you know, I'm not going to ask you anything about these things. I don't want you to feel pressured to ever be around us. And he stopped me in my tracks, and he said, no. I have learned from this already things about myself I didn't even realize I needed to know. The remorse was clear, and his actions to stop me and tell me that he had guilt are something I can't even explain. I didn't ask him, and he just told me. I think what I want to say most is I'm here on my own accord. I drove 3.5 hours to come. I don't feel obligated. I don't feel like I have to be.
Was the assailant apprehended?
There were 5 assailants.
5 assailants?
And they were apprehended the night of the crime.
Mm-hmm.
They were caught by Detective Rue. And it took about 2 years to prosecute. They did all plead guilty.
How much time, what was their sentence?
It ranged from 15 years to 20 years for all 5.
15 years to 20 years each.
Yes, sir. Well, each person was sentenced with a concurrent. So they were charged with 3 things: burglary in the first degree, armed robbery, and possession of a weapon during a violent crime. The burglary first degree was 20 years for one individual, and the armed robbery 20, and 5 for the weapon. And that process matched each person down the line.
How old were they?
They ranged in ages from 23 was the oldest person. The youngest one was about a month from turning 17.
And what year was that?
2011.
Are they still in prison?
Yes, sir. The first one will be released next year.
All right. Thank you.
You're welcome.
Your Honor, next we have Laura Blue.
Good afternoon, Your Honor. My name is Laura Blue. From 13 years being in the Beaufort area, a citizen of Beaufort, South Carolina. We were homeless, living in a hotel. It was during Christmas time. We were transitioning from the hotel to the residence in which he was allowing me to rent. And when I went into the home, graduated from Beaufort High School. He's now in the United States Navy. I have a 22-year-old daughter. She's currently the business manager at St. Helena in Port Royal. I have a 4-year-old grandchild that actually came into the home while we were there. I would say from landlord to family, that's how we look at him. Both of my children looks at him very highly as an uncle. He's very respected by both of them. In spite of what's going on, try to encourage him plenty nights through texting and sending scriptures to let him know that in the Bible, God forgives us of all our sins. He asked me when I came down and visit my family here if it was sin. He was very sorry about it. He just couldn't get over the hump of understanding that he has to forgive himself. I will tell you today, Judge, on behalf of my family, we truly, truly, by no means, look at him more than just my landlord. Again, he's my family. I rest assured his family has supported me tremendously. They didn't ask me to come, they didn't beg me to. I asked them, can I please come? Can I please, every day, what can we do? Because again, like I say, this man took my family in, put a roof over my head with 2 children. And he made sure not one day, if I was late, he overcharged me. Not one day he made an eviction notice or anything. And I've been late many of times. Yet he let us stay in the home. He was ready to renovate the home right before my son was graduating. And I was working for Department of Social Service inside Child Protective Service as an investigator, not making much money. And I told him, I said, Mr. Flemming, if we leave, where could we possibly go for the next 3 months until my son graduated? He said, you know what, you guys stay here, and when he graduates, then we'll go ahead and start the renovation of the home. So I just ask that you just take into consideration what I said about this man. Thank you, Your Honor.
Your Honor, I'm not going to read the statements because you do have letters from Kevin Green, Jay Taylor, and Tom Miller, all who were here earlier but had to go, as I said. But at this time, I'd like my client to address the court.
Okay.
And obviously, you can stand where you sit.
Judge.
Yes, sir.
Your Honor, excuse me. Thank you for the opportunity to address this court. For many years, I stood in this very courtroom representing people. Many of those people had broken the law. I was very aware that one bad decision or a series of bad decisions can have life-changing and irreversible consequences. Despite knowing this firsthand, I made some terrible decisions and I broke the law. Today, I offer this court no excuses. There are
case, a concurrent 46-month sentence is sufficient punishment and will protect the public. And I think the sentence here will serve that purpose as well. Mr. sentence, there's an enhancement called abuse of position of trust. And this was calculated in to Mr. Flemming's sentencing guidelines, and he was held accountable for the abuse of position of trust. So that's what he did. He abused his position of trust and abused his law license, and he's taken full accountability for that. You have heard about his worst days, and I hope you will also know that those bad decisions do not define his life. One of the things the court always considers in these matters is whether or not somebody has a criminal history. Mr. Flemming had no criminal history prior to this.
Great detail. And Mr. Flemming said it too, about how he pled guilty in federal court with no deals. No deals. And he talks about how the Pinckneys were considered in the pre-sentencing report, which of course the state doesn't have. We don't know what was in that. But what he leaves out, when they make this great presentation to you, how they pled with no deals, and therefore that's enough. Just let the feds handle it. We just thumbed our nose at the state, thumbed our nose at our obligations in the agreement we signed, and went down the street. What he leaves out is that he was allowed to plead.
I don't sentenced to consecutive life sentences. Now I have a lawyer, co-defendant, colleague of his, facing 195 years in prison. In addition to dealing with and sentencing all those folks, I've certainly dealt with my share of grand larceny cases, people who might steal an automobile, facing 10 years in prison, a shoplifter who, after the third offense, they're facing 10 years in prison. And I've had my share of sentencing people like the assailants who were convicted of the crimes that there was a case in this state where the amount of thievery exceeded what's occurred in this. And having complete trust in what that lawyer says to them. And of course, part of my years of practice, I've had clients come to me with, and they come and said that they didn't know how much money they got on their case, that they went to the lawyer's office and the check was turned over and they just was asked to sign the check. So they came to me to find out how much money they got in their case. But this is totally unprecedented. I cannot, there's no way. There was a case in this state where the amount of thievery exceeded what's occurred in this case. Now the presentations on behalf of Mr. Flemming were certainly inspiring. Reminded me of the revival that we had at our church last week. Reminded me of funeral services that I've had to attend, particularly within the last year. and I've heard a lot of testimonies, so much so that they can go on and on in churches, you know, at a funeral. And so we ask people to limit their comments to 2 minutes because everyone has so many good things to say. And most folks reminded me of what was said in federal court, sort of a disregard to the dual sovereignty of the state court. You know, I didn't read Judge Curry's 0 to 5, the sentence is 5 years. I wrote insurance. Is that insurance fraud?
Yes, sir.
That is count number or indictment number.
Next one's count 11, Your Honor.
Count 11.
Yes, sir.
On the exposure is 0 to 10. The sentence is 10 years. On the breach of trust with the 10-year possibility or exposure, the sentence is 10 years. On the money laundering, where the exposure is 0 to 20 years, the sentence is 10 years. On the 5-year breach of trust, the sentence is 5 years. On the 5-year money laundering, I believe it is, it's 5 years. And on the computer crime, the sentence is 5 years. And each of those will run concurrent with each other. As to the breach of trust involving the Pinckney, counts 5 and 9, is it?
Yes, sir.
Where the exposure is 5 years, the sentence is 5 years. The 30-day breach of trust, count 6, the sentence is time served. On the conspiracy charge, sentence is 5 years. On the breach of trust, where the exposure is 10 years, the sentence is 10 years. And that sentence will run consecutive to the sentence that you're currently serving. All the sentences otherwise will run concurrent with each other. I'm going to defer any restitution hearings. I believe it's just too convoluted for me to get a true handle on what the state is seeking and what should be ordered, and I tend to think that it's, well, I don't want to prejudge whether it's necessary or not, but I'm going to defer anything